No, pardon, my lord. The petition is costed more than 9 years. Offense under 302, my lord.
Bail application.
Yes, jail.
May I pardon to mention matter, my lord? There is a CRL number 181 of 2019, my lord. The accused in custody since 2014. There is a medical emergency, so that we find out.
Please use the mic.
Well, my lord, bail I have filed, my lord. He is in custody for more than 10 years, my lord.
10 years. Give it.
May I please the lordship? This is mentioning for JCRLA 17/2020. The co-accused is in bail and the petitioner is in jail custody for more than 8 years. And another mentioning for a CRLA 151/2019, the petitioner is in jail custody for about more than 10 years.
10 years. Give it.
Obliged, ma'am.
Appellants in custody more than 8 years.
Maybe pardon. This is a criminal appeal 622 of 2015. I am in custody for more than 17 years. Can the bail application be listed in course of this week?
Why are you not filing the memo?
I have filed memos, my lords. Memos are there from the date the court has reopened. Memos have been filed.
No, list it.
I'll give another memo to us.
Yes.
May I pardon? My lord, death offense cases, my lord, item 1 and 2 both are there. My prayers, my lord, let us take the item 2, my lord, first.
2 means Mr. Panda.
Panda, he is ready also.
Where is he?
He is coming.
Okay. So will take. You want that it will be taken up fast.
Then so that I'll get some time also. Both in case I am.
Oh, you are there. So you have prepared. You have prepared for 2. Okay, then there is no problem.
What I am also hearing now is probably the new Advocate General may be appointed either today in the evening or tomorrow.
We do not know.
No, that's what I am hearing. So but if item 2 is going to be taken up first, then may I request item 1 may be taken up tomorrow at least. I may be accommodated.
No, Mr. Panda, once it is started means at least we hope that it will be taken up for 2 days at least.
So till tomorrow I am
Hi.
Fresh admission item 3 टा खाली
Fresh admission নিয়া হবো তো প্রথমের লেখা
আগে না সে 2 টা কোশ্চেন তো সে
No, সেটা হিয়ারিং রে সে ইয়েটা ଅଛି যে जो फ्रेश एडमिशन ऑर्डर्स मैटर विल बी टेकन अप फास्ट से सरी गला परे हियरिंग मैटर डेथ रेफरेंस नो निया जे यही पेजी यस
Weekly list fresh admission item number 3.
My lord, here committing murder of 5 persons, my lord. The appellants convicted under section 302, 149 and 148.
Life imprisonment.
Again. 5 persons, deceased persons are 5 in number.
There are 3 appeals.
ଯେମିତି ଆସିଲେ ମୁଁ ସେଇ ଅନୁସାରେ ଫାଇଲ୍ କରିବି।
ନାଇଁ 2 persons are left out.
ଆଜ୍ଞା
ପାଖକୁ ଆସିନାହାନ୍ତି ଆଉ 2 ଜଣ ଅଛନ୍ତି।
ନା ଆହୁରି ଅଛନ୍ତି ବହୁତ।
ନାଇଁ କେତେ ଜଣଙ୍କୁ ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ ହେଇଛି ମୁଁ ସେଇଆ
ଟୋଟାଲ ମାଇଲ 20
ଓହୋ 20 accused persons.
ଆଜ୍ଞା
And all of them have been found guilty.
ଆଜ୍ଞା
Okay. Is there any previous appeal, criminal appeal filed?
Running page 78.
No. Yeah, I just want because it is to be tagged to those appeals.
Yes.
Maji. Sadasiv Angara. Okay, there are number of appeals filed, but those are in defect, so that is how it was. Okay. All right, heard Ms. Mahapatral and counsel for the appellant and counsel for the state admit call for the trial court record, interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. These matters shall be listed along with CRLA number 477 of 2024 and CRLA number 478 of 2024. Same order to be passed in the other two items. Okay?
ନା ଆଉ ଗୋଟେ ମୁଁ ଫାଇଲ କରିଥିଲି
ସେଗୁଡାକ ଲେଖିଦେବେ ଏଇ ନମ୍ବର ଗୁଡାକ ଲେଖିଦେବେ ଇଏ
ଆଉ ଗୋଟେ ଫାଇଲ କରିଥିଲି 478 ମାଇଲ ସେଟା 478 ଆସିଛି 479
479 ଫାଇଲ କରିଥିଲେ
ଆଜ୍ଞା
କଣ ଡିଫେକ୍ଟ ଥିବ ସେଇଥିପାଇଁ ଲିଷ୍ଟ ହେଇନି
ନା ନମ୍ବର ଆସିଲାଣି ପରା
ଓହୋ ତାହେଲେ ଡି ଟା ନାହିଁ
ନାଇଁ ନାଇଁ
ଦେନ୍ ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍ ସେ ଗୋଟେ କଣ କହିଛନ୍ତି ସେଟା ଦେଖିବ ଲିଷ୍ଟ କରେଇଦବ ସେଟା
ଆଜ୍ଞା
CRLA number 479 something of 2020. Yes, next.
Item 4.
Yes, Mr. Tripathi.
Copy not submitted.
Copy that jail criminal appeal
Yes.
ଆପଣଙ୍କୁ ଜଜମେଣ୍ଟ କପିଟା ଦିଆଯିବ ପ୍ରିଜନର୍ସ ପିଟିସନଟା
Yes.
ଦିଆଯିବ ଏଇଟା 302 and life imprisonment ହେଇଛି fine of rupees 5,000. हार्ड एडमिट अच्छा डिले कंडोन कर देवे 18 दिन डिले डिले कंडोन हार्ड एडमिट कर देवे सो एंड सो साथ ही कर देवे जाको एंगेज करेंगे और registry shall supply copy of the prisoner's petition along with the impugned judgment to the learned counsel for the state hala our intimation is to be given to the appellant regarding engagement of the counsel hala आइटम नंबर 2 ता कहि दीचो आगुर निया जियो बोली प्रथम रे हां ठीक है चलो
Item 5.
In this case, my lord, I have no instruction, but I gather the information from the co-villager that appellant is dead. So, lordship indict the government counsel to ascertain whether it is a fact.
Case of conviction.
Yes, my lord.
What sentence has been imposed?
My lord.
302 अच्छा life imprisonment. लिखी दियंतु Mr. Nan Bihari Das, Land Counsel, appearing for the appellant, submits that he has received instruction that the appellant is dead. Let the Land Counsel for the state obtain instructions to the inspector in charge of Bhuvan police station regarding such aspect. Next week रख देला अपन कह दे.
Next week copy maybe sir one copy.
Copy, I missed the file.
Free copy of the order will be handed over to you.
Yes.
You want the copy pen drive रे नहीं जानते जैसे मर जाइए आप कौन करिए.
I have also missed the file, my lord.
Huh?
I have also missed the file, my lord. File is not
So it's
reachable.
all right. Let the instruction come.
Yes, my lord.
If you want, if the appellant is alive, then if you want to continue, we'll supply everything to you. Okay.
My lord. My lord.
So it will be listed on 8th July 2020.
Yes, sir.
Free copy of the order.
Item 6. Item 7.
May I please, Lordship? So, live conviction. The petitioner was in custody more than 14 years, 5 months.
Custody certificate or
That is a
report
flag F.
flag F टा टिके देखिल
Since 4/2/2010, he was in custody.
ना कौन
Sarathi Pradhan.
आरती प्रधान सेति नंबर अच्छा सेटा एटा 11 वर्ष 3 मास 24 दिन लेखा है केबे का रिपोर्ट एटा रिपोर्ट पाइला किए देला रिपोर्ट हां हां किए पठई जी कोन है जी रिपोर्ट आसला रिपोर्ट
I have no such report.
अरे कोर्ट रिपोर्टर अछि कोर्ट आसला कोइ परिबेनी अपन अपन कुआई को प्रोड्यूस करिया पे
No.
Mr. Roy, you produce the custody certificate.
No, matters.
अपन प्रोड्यूस करना थी ता सी प्रोड्यूस करना थी कोर्ट रिकॉर्डर केमती आला रिपोर्ट नहीं 6/9/2023 रो एटा टिके देखिलो ऑर्डर नंबर सीरियल नंबर 17 ये जो हाँ आइटम नंबर 7 ना ये जो for hearing and so on so it लिखा है report regarding custody period of appellant at flag A may kindly be seen ऑफिस नोट रो 6/4/2023 सीरियल नंबर होची 17 पूर्वर ऑर्डर कौन अच्छी 16 नंबर ऑर्डर रिपोर्ट रिगार्डिंग कस्टडी सर्टिफिकेट में आ जाता पूर्वर भी से लिखा है 14/3/2023 23/2/2023 रे bail stay relation of two sets of available नहीं ये 23 ପରେ 14/3 ରେ ଆସିଛି 23/2 ରେ କିଛି ଅର୍ଡର ତ ପାସ୍ ହେଇନି ଫ୍ଲାଗ ଏପର ସେ ଗୋଟେ ପେଜ ତ ଅଛି ନା ଅର୍ଡର ମୁଁ ଦେଖୁଥିଲି ତାର ରିଲେଟେଡ ଅର୍ଡର କିଛି ଅଛି କି ନାହିଁ ତାପରେ କିଏ ପଠେଇଛି କୋଉ ଡେଟ୍ ର କଷ୍ଟଡି सर्टिफिकेट ନାହିଁ have you got any custody certificate
No.
with you because this custody certificate which is available in case record that does not indicate on what date it has been issued and who has issued it
My lord.
and it reflects of course that it is for 11 years 3 months 24 days
But he has never availed any interim bail even.
it's all right but once we rely this document particularly we must know that from which source it has come to the record right
Well.
so Mr. In which jail he is now
Parlakhandi.
so you get the instruction that would be better let it IA number no it is ଆପଣ କେତେ ଜଣ ଆଜିରେ appellant ଅଛନ୍ତି
Only one.
so ଏତେ ଗୁଡା କଣ bail application file କରିଛନ୍ତି
ସେଟା ବହୁତ ପୁରୁଣା
miss case number 2014 for bail IA number 2019 ରେ
Well, only except 1976 other my lord your lords may dispose.
अच्छा ଗୋଟେ appellant ତ
Yes.
अच्छा लिखନ୍ତୁ the learned counsel for the petitioner appellant लिख ଦିଅନ୍ତୁ does not want to press Miss case number 130 of 2014 and IA number 1381 of 2019 ହେଲା এটা প্রথমে করে দেবে তারপরে 1381 of 2019 দিটা not press ହେଇଗଲା ବାକି ଆଉ ଗୋଟେ ରହିଲା IA number 1976 of 2023 ହେଲା this is an application for bail. Let the London Council for the state obtain the custody certificate, so also criminal antecedent, if any, against the appellant. Put of this matter on 8th July 2020.
Item 8.
Interim bill. Interim bill. Bail na interim bill.
Bail by court. Last, please, your lordship. At last occasion, your lordship had call for the criminal antecedent of the appellants. In custody.
Yes, of course, that order we passed on 15/5/24. You are appearing for appellants number 1, 2, and 3, Mr. Jafrullah.
My lord, I was appearing, but in the meantime, he has made a prisoner petition to engage some other lawyer, my lord. And
Who?
I'm for
Who?
2 and 3. They have disengaged me.
So,
I'm now appearing only for appellant number 1.
just a minute.
This is
A1
flag
law,
X.
Mr.
Prison.
S.K. Jafrullah.
Either.
So who is appearing for A2?
My lord,
I'm for the filed the appeal, but then I was disengaged. Now I have been engaged for appellant number 4 once.
Appellant number?
4.
We just
Service for 2 and 2.
Appellant number 2 and 3.
2 and 3. What
Yes,
is your good name, London Council?
S.K.Sahoo.
Yes, sir. You have filed power for them.
Yes, my.
All right. And then A4, Mr. Panda, you are there.
Yes.
And there are 5 appellants, no?
one is dead.
One is dead.
One is dead.
One is dead, 4 appellants.
Your lordship will remember when your lordship was sitting with Justice Vinod Prasad, this appeal was badly heard, but it could not be come.
Dead means A5 is dead.
Yes.
My lord.
So Subhranshu Kumar Das.
Tony Alias.
Tony Alas.
He died in custody.
So Mr. Tripathi,
Yes, my lord.
an order was passed on 15/5/24
Yes.
to obtain instruction regarding criminal antecedent against appellant number 1 to 4 through inspector in charge of Lalbagh police station, so also about the conduct of the petitioners in jail custody through superintendent circle jail Chaudhar, and you are to further obtain instruction that if there is any chance of law and order situation in case appellants number 1 to 4 are released on bail. What is your instruction?
That is the instruction received on 26/6/23. That is
कौन file कौन instruction
the
asla?
petitioner Vishwanath Velar alias Vishwanath Vera is a hardcore antisocial and earned a very bad reputation in the locality. He is also found involved in Lalbagh PS case number 67 under section 302, 307, which was charged seated by the Lalbagh PS
this section 302 Act. In that case, he was absconded and arrested on 23/11/2008 and was in jail custody. After coming from the jail on bail, he has committed this crime. He is also found involved in Lalbagh PS case number 30 of 12 under section 341, 323, 294, 506. If he will release on bail, his presence in the locality may create discontentment in the family of the deceased, who are also residents of the same locality, and may create breach of peace and bloodshed.
Okay, what about number 2, Keshav Behera alias Montu?
That is it.
You have obtained the report in respect of all the appellants.
I think so. That's checked.
So if you have received,
Yes.
what we want that let it be supplied to the respective counsel, let them have their say on this matter.
Yes.
If they have got criminal antecedent or whatever, if they have committed some offenses, what is the status of those cases, they may say about it. And whatever you have mentioned, they may say about all these things. So if you have received, then we can pass
Right.
the order.
I have received only this person, Vishwanath Behera.
Then why there was an order on 15/5 to obtain it in respect of all the appellants through IAC Lalbagh, also through Superintendent of Service.
Let it come next week. I will.
And free copy of the order was also supplied to you.
Yes, please.
Do you? Then you do one thing.
Yes.
Whatever you have got, that was in respect of appellant number 1.
Vishwanath Behera.
Right. So Mr. Jafrullah is appearing. That copy may be supplied to him. But we'll decide all the bail application one day. We are giving you. It will come on 15th July.
Yes.
In the meantime, you obtain in respect of the other 3 appellants and also supply in advance to the Land Council so that they can have their say on this matter. Okay.
My lord, I have a say.
Yes.
I am appealing on behalf of the informer.
Ah.
I request my both the friends to supply their interim application.
All right.
They cannot be supplied to Mr. Mahapatra. It has to be supplied to his associate.
Okay. It is stated at the bar that for appellant number 1, Vishwanath Behera alias Vilar, Mr. S.K. Jafrullah is appearing. And for appellants number 2 and 3, namely Devraj Behera alias Litu and Keshav Behera alias Montu and Devraj Behera alias Litu, Mr. S.K.Sahoo is appearing along with his associates and filed wakalatnama.
Yes, ma'am.
Okay. And so far as appellant number 4, Sheikh Rahul alias Sheikh Sahid is concerned, Mr. Devasis Panda and his associates are appearing. It is further stated at the bar that appellant number 5, Subhranshu Kumar Das alias Tony is dead. An order was passed on 15/5/2024 by order number 57, asking the Land Council for the state to obtain instruction regarding criminal antecedent in respect of all the 4 appellants, that is appellants number 1 to 4, through inspector in charge of Lalbagh Police Station, so also about the conduct of the petitioners in jail custody through Superintendent Circle Jail Chaudhar, and to further obtain instruction if there is any chance of law and order situation in case the appellants number 1 to 4 are released on bail. Copy of the said order was supplied to the Land Council for the state. Mr. Tripathi Land Council, appearing for the state, submits that he has received instruction about the criminal antecedent and also taken instruction in respect of the appellant number 1 as per this aforesaid order dated 57 number 57, but so far as appellants number 2, 3 and 4 are concerned, some further time may be given to him to obtain the instruction. Put up this matter on 15th July 2024. The instruction which has been received in respect of appellant number 1 may be supplied.
I have supplied.
Has already been supplied to Mr. S.K.Sahoo in court today, who seeks some time to file a comprehensive affidavit. So far as the instruction relating to appellants number 2 and 2 to 4 are concerned, the same may be obtained and supplied to the respective counsel in advance to file the comprehensive affidavit, if any, by the next date, serving the same on the Learned Counsel for the state, so also on the Learned Counsel for the informant, Senior Advocate Mr. Saurachandra Mahapatra. Mr. Jafrullah will also do the same. Okay. Matter will be listed on 15th July 2024. In the meantime, Learned Counsel for the state shall also obtain instruction whether appellant number 5, Subhranshu Kumar Das alias Tony.
That your lordship can call for a report from the jail superintendent. He died in jail custody.
Oh, jail. Acha. While he was in jail, he died.
Yeah.
It is still exam in jail. So let a report be called for from the superintendent to Circle Jail Chowdhury. Whether the appellant number 5 one.
A free copy.
Free copy of the order. 15/7/2020.
Item 9.
Please, my lord. My lord, here the appellants have
Judgment, it appears that 6 persons face trial.
my lord.
So here
They have been convicted on 302 with 140, 48, 149.
no, ये जो बाकी जो 4 जन रहिले
आज्ञा
ये तो 2 जन हला आउ 4 जन सेपरेट क्रिमिनल अपील फाइल करथिले.
No, separate criminal appeal, yes. Tag, but all the appeals are tagged together and heard together, and my lord also granted bail. Out of 3 of them have already been granted bail.
ये जो आपण कहउछन्ती 3 जन जो बेल लेइछन ता ऑर्डर अछि कॉपी बेल.
I have stated my lord, sir, para order copy, sir. Sir, that is 218 of 17, 220 of 17, 221 of 17.
Don't be so fast.
Sir.
What is the criminal appeal numbers of the other co-accused
Sir,
persons?
sir. 218 of 2017.
CRLA number
218 of 2017.
What is the name of the appellant there?
Dhanpal Machi. Dhanpal Machi.
Dhanpul Machi. Dhanpul Machi.
Acha.
Dhanpul
Machi.
Dhanpul Machi.
Okay. When he was granted bail?
My lord, he was granted bail
on 20/5
so 20th, the order is with me. 20th 5 2023.
May 2023. Okay. Then what about the other?
Other also in the same day. They have also granted bail in the same day.
One is this Dambur Maji bail. Acha. So that is CRLA 220
Dambabu Maji,
2017. Dambaru Maji. Then Audara Dambu Maji. That is CRLA 221 2017. Dambu Maji. Okay, the same day all of them have been granted.
My lord.
And the reasoning given, your submission was that 2014 in custody. And as for the evidence of PW2, the wife of the deceased, Shadanand Bidhar, who is not only injured but an eyewitness to the occurrence, the petitioner along with the co-accused persons assaulted the deceased by means of lathi and Paha Run, an instrument to thrash paddy at the time of reaping. Acha. Learned counsel further submitted paperwork is so and so, no chance of. State, on the other hand, opposition also placed the evidence of so and so, and the doctor who conducted post-mortem examination over the dead body noticed number of injury and different parts opined that the cause of death is serious. Okay. So, Mr. Tripathi,
Yes, ma'am.
whether these three persons who have been granted bail and the present two appellants, Nori Maji and Dolly Maji, they are on same footing as per the evidence of PW2.
PW2 ମିଳିଲା eyewitness.
ଅଛି ତ ଆପଣଙ୍କ ପାଖରେ
ହଁ,
ସାକ୍ଷୀ
ହଁ, ହଁ.
PW2 ର ଏଭିଡେନ୍ସ ଟା କାଢିଲେ ଟ୍ରାଏଲ କୋର୍ଟ
Para 2 ମିଳିଲା.
para 2
Yes. One Tuesday in the month of Magh. Yes.
ହଁ para 2 ରେ କଣ ଲେଖା
Yes,
ହେଇଛି
one Tuesday in the month of Magh of this current year at about 7 p.m. in the evening, accused Dali came to our house and called my husband to go to take salap rasa, and accordingly my husband went with him. After a little while, on hearing some noise, I went to the backside of the house of the accused Lobo and Damu, and found the accused Dhanpal Maji, Nori Maji, Dali Maji, Damu Maji, Dombabu Maji, Lava Maji, Lai Maji. The witness correctly identified the accused person standing in the dock, along with Purno Maji and Rajiv Maji, assaulting my deceased husband by means of thenga, badi, and pahuran, an instrument to thresh paddy at the time of reaping. On seeing the assault of my deceased husband, I tried to intervene by lying over his body, but the accused Norimaji and other accused person also assaulted me on my right leg and threatened me to take away my life, for which, being frightened, I went away to a little bit distance and concealed myself under a mango tree and watched the assault of my deceased husband. At the dawn of the next day, I went to the village Padmathopa to inform my in-laws, and after knowing about the incident, my father-in-law and mother-in-law and other villagers, along with my parents, came to the spot and saw my deceased husband lying dead. On this incident, my father-in-law reported the matter to.
So, Mr. Tripathi, it appears that so far as the assault part is concerned, it is almost identical like the person.
Yes.
But what about the custody? You say
10 years, 5 months.
Nori Majiro custody.
Same. 10 years, 5 months. 14 to 2014, he is in custody.
14 to
2014.
14. And what about this under?
Same.
Dali.
Yes, sir.
Final form bar kale. ଅଛି ଠିକ ଅଛି ଆଉ ବେଲ ରେ ଯାଇ ନଥିଲେ ତ
No.
These persons are in custody. These persons not produced. These persons produced in custody. Produced from custody. ଆଉ ଏ କୋର୍ଟ ରେ ଆପଣ ଯାଇ ନଥିଲେ
No.
ସେମ୍ ଏ ଯୋଉ ତିନିଟା ବେଲ୍ ଅର୍ଡର ଅଛି ତାକୁ ଦେଖିକି ଲେଖିବେ ତା ନମ୍ବର ଦେଖନ୍ତୁ the learned counsel for the petitioner submitted that the petitioner is in judicial custody since 14 to 2014 and as such he has remained in custody for more than 10 years. He further submits that the similarly situated co-accused persons, namely Dhanpal Maji Damburu Maji and Dambu Maji, who have filed separate criminal appeals. That is CRLA number 218 of 2017, CRLA number 220 of 2017, and CRLA number 221 of 2017, respectively, have been granted bail by this court as per order dated 25/2023. Land Council further submits that though paper books have been prepared, but there is no chance of early hearing, and the conviction of the petitioner mainly rests on the evidence of PW2, the injured eyewitness, and there are good chances of success in the appeal, and therefore the bail application may be favorably considered. Learned counsel for the state place the evidence of PW2 and fairly submits that as per the evidence of the said witness, the allegation of assault against the petitioners, so also the co-accused persons who have been enlarged on bail, are similar in nature. Considering the submission made by the learned counsel for the respective party, period of detention of the petitioner in judicial custody, release of the co-accused persons on bail in the connected CRLA, and absence of any chance of early hearing of the appeal, we are inclined to release the petitioner on bail. Same terms and conditions, and that would also be the order in the connected CRLA number 217 of 2017, and pass an order that it should be listed along with CRLA number এই যে তিনটা নম্বর কইলি 218 220 and 221 হলো।
Item 10.
May plus. I filed my wakalatnama on the basis of a petition.
Yes, Mr. Dwivedi.
I filed my wakalatnama on the basis of a petition received.
Acha, prisoner's petition, period the prisoner's petition at flat C for engagement of Mr. Suryakant Dwivedi in place of Mr. Ashok Banerjee. Mr. Dwivedi has already filed Bhinama, which is accepted. The name of the earlier engaged counsel shall not be reflected in the cause list henceforth. Yes.
Appellant is aged about 69 years and custody since 25/1/2014.
25/1/2014,
madam.
So what is the conviction and what is the sentence imposed?
Sentence is life under section 302.
302.
Yes, ma'am.
It is supply the deposition copy.
You have not received.
He has not supplied.
You give your pen. Acha, that is available.
Just now.
All right.
In the meantime, your lordship may call for the custody certificates.
Okay. Miss case number, which jail he is now?
And sub-jail Nayagar.
Sub-jail Nayagar. Miss case number 1194 of 2017. There is an application for bail. The learned counsel for the petitioner submitted that the petitioner Jonathan, that the petitioner is in judicial custody since 25/1/2014, and he has supplied the copy of the deposition of the witnesses examined in the trial court to the learned counsel for the state in court today who seeks some time to go through the same. Put up this matter on 8th July 2024. Learned counsel for the state shall also obtain the custody certificate from the concerned jail superintendent. So also take instruction about the criminal antecedent, if any, against the petitioner. In the meantime, free copy of the order be handed over to the learned counsel.
Item 11.
May I please? Last official was directed the state to take care regarding criminal antecedent.
ଆଣିଲେ କି?
Yes, sir.
କଣ ଅଛି?
Yes, ଗୋଟେ ଅଛି 302.
ଆରଟା ବି 302.
ଏଇ
So
ଗୋଟେ
what is your instruction?
ଏଇ ଗୋଟାଏ ମୋ
ଏଇଟା ସେ କହୁଛନ୍ତି ଆଉ ଗୋଟେ ଅଛି ନା କଣ?
Another ଲେଖିଛି. Another case by Sarat PS.
Another case ଲେଖୁଛି ପରା? ଏଇ ୟାର PS case number କେତେ? ଶରତ PS case number 24 ଆଉ ସେଟା ହଉଛି 17 of 2022. 17 of 2022 କେମିତି ହେଲା? ଇଏ କଣ ଯାଇଥିଲା କି ବେଲ୍ ରେ?
No, my lord.
ହବ କେମିତି? ସେଇ ଇଏ ପିରିୟଡ ରେ ଯାଇଥିଲା କି କୋଭିଡ ପିରିୟଡ ରେ? ଆଉ ଗୋଟେ 302 କେମିତି ହେଲା?
ନିଶ୍ଚୟ ଯାଇଥିବ ନା otherwise
ଚାର୍ଜସିଟ୍ ବି ହେଇଗଲାଣି ଆପଣଙ୍କ ନାଁରେ? Instruction ନିଅନ୍ତୁ ଆପଣ। ଲେଖନ୍ତୁ। As per the order dated 26/6/2024, এটা ଲେଖିବା IN number 1628 of 2007. The Learned Counsel for the state has obtained instruction through the inspector in charge of Sarat police station that there is another case, that is Sarat PS case number 17 dated 23/2/2022 under section 302/34 of the IPC against the petitioner, which has ended in charge sheet. Stop. The written instruction is taken on record. You supply a copy of the said instruction has already been supplied to the Learned Counsel for the petitioner who seeks some time to obtain instruction in that respect. So what is your custody date?
Custody 30/8/2015.
The Learned Counsel for the petitioner
15/9/2015.
submitted that the petitioner Raghu Purti is in judicial custody since 15/9/2015. Let the custody certificate be obtained by the Learned Counsel for the state in the meantime. ସେଇଥିରୁ ଜଣା ପଡିଯିବ ସେ ଯାଇଥିଲା କି ନାହିଁ, ସେ ପ୍ୟାରୋଲ ରେ କି କଣ ସେ ହେଲା। So
କୋଉ ଜେଲ?
ଉଦଳା ଜେଲରେ।
କୋଉ ଜେଲ?
ଉଦଳା।
ଉଦଳା।
Yes, ma'am.
ଭି ନାମା ଦେଖଉଛି ସବ୍ ଜେଲ ଆଚ୍ଛା ସର୍କଲ ଜେଲ ବାରିପଦା ଦେଖଉଛି ଆପଣଙ୍କର ଭି ନାମାଟା।
Shifted to ଉଦଳା।
ଉଦଳାରେ ଅଛି। ନେଇ ଆସନ୍ତୁ। ଏଇଟା ଆସିବ 15 ତାରିଖ ଦିନ। ଆପଣ ବି ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ ହେଲା। 15/7/2024. Yes.
Item 12.
Please, my lord. The appellant has been convicted for 302 live conviction. I have for bail of the appellant number 3 is in custody since 3/7/2014, my lord.
Appellant number 3 ପାଇଁ bail କରିଛ।
ଆଜ୍ଞା।
ଆଉ ଗୋଟେ କଣ interim bail ଗୋଟେ କଣ ଆସିଛି? ସେଟା କିଏ ଫାଇଲ କରିଛନ୍ତି? at flag D। ହୁଁ 867 ଟା 3/4 ପାଇଁ ଫାଇଲ ହେଇଛି interim application for bail। ଆଚ୍ଛା ଦେନ୍ ଆଉ ଗୋଟେ ଆପଣ ଆପ୍ଲିକେସନ ଦେଇଛନ୍ତି 2000 ଆପଣଙ୍କର ଦିଟା ବେଲ୍ ଆପ୍ଲିକେସନ ଫାଇଲ ଅଛି ଆପେଲାଣ୍ଟ ନମ୍ବର 3 ପାଇଁ। ତ କୋଉଟା ଆପଣ ପ୍ରେସ୍ କରିବାକୁ ଚାହୁଁଛନ୍ତି?
Last, let it come next week. I will verify because this is a transport with my lord.
No, it's all right. One is 1874 of 2019.
My
That is the bail application of appellant number 3.
My lord.
ଆଉ ଗୋଟେ ହୋଇଛି IN number 580 of 2023. ସେଟା ମଧ୍ୟ bail for appellant number 3. ତେଣୁ if
That
you have
copy is with me. That is 580 of 2020.
580 ଆପଣ ଫାଇଲ କରିଛନ୍ତି।
ଅଛି ସେଟା ମୋ ପାଖରେ copy। ଆଜ୍ଞା।
ହଁ then the other one you are to not press
Not
it।
press, my lord.
अच्छा लिखी दियो IN number 1874 of 2019. The Land Council for the appellant number 3 seeks permission not to place this interim application accordingly disposed of as not pressed. Then what is your submission so far as 580 of 2023 is concerned?
So for 580 of 2023 is concerned, the petitioner is in custody in 3/7/2014, my lord.
3/7/2014.
14.
Yeah.
So far, conviction is based only on the statement of the PW1 and PW2. PW2 is the eyewitnesses who is a child of 10 years old. There is
Your bail application was earlier rejected on merit or what? Or this is the first one?
This is the first one. So far, my instruction is
Let
concerned.
us see that.
Earlier bill rejected, my lord. 5/8/19.
You are right, Mr. The ଜଣକୁ ବେଲ୍ ଦିଆ ହେଇଥିଲା appellant number 2 S. Sasi Dora.
She is the mother of the present appellant.
So far as you are concerned 1-3-4 bail application ସେଇ order ରେ ହିଁ reject ହେଇଥିଲା। So 5/8/2019 rejected। ତାପରେ ଆଉ ଫାଇଲ କରିଛନ୍ତି ନା ନାହିଁ? Then you are released on bail on 21/11/2022.
I have already surrendered, my lord.
For 10 weeks you have been released on bail. Then ତାପରେ ଆଉ ନାହିଁ। So what is the conduct of the petitioner, this appellant number 3, when he was released on bail by this court
I'll take
for a
instruction.
period of 10 weeks? Okay. The Learning Council for the এটা লিখিবে there is an application for bail for appellant number 3 ନାଁଟା ଲେଖି ଦିଅନ୍ତୁ S Bhagavati Dora. It appears that the earlier bail application of the petitioner was rejected by order number 8 dated 5/8/2019 in IA number 1951 of 2018. However, the petitioner was granted bail for a period of 10 weeks as per order number 12 dated 21/11/2022 in IA number 295 of 2022. The Learning Counsel for the petitioner submitted that in compliance with the said order, the petitioner, after availing the interim bail period, has already surrendered and he is now in judicial custody. Let the Learning Counsel for the state obtain instruction regarding the conduct of the petitioner during the period of interim bail. So also produce the custody certificate by the next date, which is fixed to 15th July 2024. Free copy of the order be handed over to the Learning Counsel for the state. So two things you are to obtain: conduct and custody certificate. Yes.
Item 13.
May I please, Your Lordship? On behalf of my senior who is suffering cold and fever. Me to another day kindly.
What do you want, madam? Adjournment?
Yes, my lord.
Which date you want this matter? Next week or a week after?
1 week, my lord.
If you will list it on 8th, whether it will do, or you want it to be on 15th July?
15, my lord.
Which one? 15th or 8th?
8 and
15. All right.
My
Week
lord.
commencing from 15th, it will be listed.
Yes, my lord.
Okay. For the entire week, there will be there. So any date you can move that application. The Learning Counsel, a mention is made on behalf of Mr. Pradeep Kumar Pradhan for adjournment on the ground of that is the council is not well. Put up this matter in the week commencing from 15th July 2024. Yes.
Oblige, my lord.
Item 14.
My lord, the conducting counsel is at another court. Please pass over the matter.
Okay.
Obliged.
Item 15.
Please, my lord. My lord, here the appeal arises out of an order passed by the London Session Judge, my lord, the Kandhamal and Fulwani, and the London Session Judge pleased to convict the appellant accused under section 302 and to sentence the imprisonment for life. My lord, here the case is that there was a family dispute, and out of these
just
sir.
Give a pause for a moment. Mr. Panda.
Sir.
Mohit Agrawal was the counsel earlier. We perhaps engaged him. Then you have entered appearance. Okay. By filing Bhinama without the consent. Okay. Mohit Agrawal को किया कोर्ट एंगेज करते लेना कौन? Right. Order dated 11/7/2018. Since the appellant has engaged Mr. Niranjan Panda and his associates as his advocate. Mr. Mohit Agrawal was appointed as per the court order dated 11/7/2018. The name of the counsel who has answered will not be indicated in the cause list henceforth. He is discontinued. Now, item number 15 रे आपनकर single appellant तो
Only sir, single appellant.
Lalchi Sahu. So, what is the date of custody?
My lord, 10/10/2016. Near about 8 years.
And here is a case where you have been found guilty
Under section 302.
302.
My lord. My lord, so far the fact is concerned, there was a family dispute.
Let us see
Sir.
Judgment. Judgment our kena? Yes, 302 life imprisonment. Earlier, you have never
No.
approached this
No.
court for bail.
No.
So, who is that deceased Chanchola Sahu?
Chanchola Sahu.
How you are related to the deceased?
No, it's between, that is nephew and this is auntie, uncle's wife.
No, the deceased.
Actually, he was wanted to assault somebody else. In between, when there was a quarrel, she wants to interfere.
Please come to the prosecution case. Please place that paragraph number 2 of the judgment.
Sir. The prosecution case in the trial with following facts. The accused is also nephew, the brother's son of Phimo Sahu, the informant and his neighbor in Sundisahi village, Bolandapoda. On 10/10/2016 at about 3:45 p.m., the accused came in front of the house of the informant and quarreled with his wife, Chanchola. Suddenly, he attacked by means of a tangia and dealt blows on her neck and head. Helpless woman fell down on the ground, profuse bleeding, and died. Her husband, who then was returning from the grazing the cattle, saw the incident and rushed. The accused, after assaulting the woman, fled OIC Gochapada police station. He received a telephonic call of the incident. He entered the fact in the PS station diary entry.
So there are eyewitnesses.
Yes, eyewitness 14345.
PW1, then
PW1, then my lord, the PW
1 to 6 and
yes.
5 is the injured eyewitness.
1, 2, 3, 4, and 5.
PW5 is the injured.
Injured.
They stated about that how in Tangia
yes.
And who is the doctor who conducted?
15. PW15.
PW15.
Yes.
Last witness for PW10.
PW9 is the doctor.
Sorry, sir. PW9.
So, how many blows you have given as per the postmortem report?
Only single blow.
Single blow?
No, my lord.
The external injury, my lord, the one incisive wound size 3 into 20.5 and 3. Then one chopped wound size 3 into 3 above the injury number 1. One chopped wound 4 into half and 3 above the injury number 2, cutting the contents of the triangle of the left neck, the cerebral vertebra 3 to 5 dismembered into 2 pieces. One inside wound size 3 into 3 into 4.
चारिटा blow ଦେଇଛନ୍ତି ସବୁ ଗୁଡାକ neck portion ରେ ଆଉ ଯୋଉ number 3 ଟା ଗୋଟେ chopped wound ମାନେ cervical vertebra number 3 to 8 F3 to 5 କୁ ପୁରା ଦି piece କରି ଅଲଗା କରି ଦେଇଛି ଗୋଟେ
The injuries were anti-mortem in nature and were also homicide. The inside.
You have assaulted a lady and you have caused this sort of injuries. Why bail will be granted to you? Paper book has been prepared.
No. Appropriate.
2018 appeal. So paper book will be prepared and see that. Or the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the petitioner submitted that the petitioner is in judicial custody since 10/10/2016 and there is no chance of early hearing and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that PW1 to PW6 are the eyewitnesses to the occurrence and PW5 is an injured eyewitness and the petitioner assaulted the deceased, who is a lady, by means of tangia, and the postmortem report wide exhibit 8, which has been proved by the doctor bracket PW9, would indicate that the deceased has sustained as many as 4 incised and chopped wounds on and around the neck, and the doctor further opined that the incised wounds were possible by sharp cutting weapon and were antemortem in nature, and the cause of death was due to acute hemorrhage due to sudden spotting of blood from arteries bracketary external carotid, 1/3 of the internal carotid, and veins external jugular and sympathetic chain coming from bracketary coming from spinal cord of the left leg, and injuries to the vital parts of the neck leading to shock and instantaneous death. The doctor also examined the weapon of offense, that is axe, produced before him and opined that injuries found on the body of the deceased could be possible by such weapon. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced during trial, the manner in which the petitioner has assaulted the deceased and caused number of injuries on the vital part of the body, we are not inclined to release the petitioner on bail. However, since the petitioner has remained in custody for more than 7.5 years, the office is directed to expedite the preparation of the paper. Yes, next.
Item 16.
May I please, my lord, on behalf of Mr. S.K. Trivedi, kindly warn your captor.
Mention is made on behalf of Mr. Suryakant Dwivedi to adjourn the matter. Is mentioned that IA number 304 of 2019, this is an application for bail. 15 तारिख रे लिस्ट कले चलिबो ना आउ डेरी चाहुचंती
1 week after.
1 week after तो 15 तारिख आपण जदी आउ चाहिबे ना 15 रे लिस्ट कले चलिबो
22
22 put up this matter in the week commencing from 22nd July 2020.
Item 17.
Oh, bless my lord.
Here, my lord, the petitioners gave a X blow on the head of the deceased lordship, deceased mother lordship.
Just a minute. Single appellant.
Yes, my lord.
What is the date of custody?
Custody, my lord. 3rd May
Please use the mic properly.
3rd May 2015, lordships.
Name
9
of the
years,
deceased?
my lord.
Name of the deceased?
Mijari Munda.
Mijari.
Yes, my lord.
Mother of the accused.
Yes.
Oh, mother of the accused. So why you killed your mother? Direct evidence or circumstantial?
Yes, no, my lord. Eyewitness there.
Eyewitness.
One
Who are
child
the
witness there,
eyewitnesses?
PW11.
PW11.
Yes. The nice of the accused lordships, who is the only eyewitness to the occurrence, my lord.
What is she has stated?
9 years, my lord.
कौन कहला कौन काहे मारले मां को कोथरे मारले
By means of
Axe.
axe
Yes.
who portion ने मारले
Head
Neck.
lordships.
neck रे
Yes.
केतेटा blow ଦେଇଛନ୍ତି
One single blow, lordships.
single blow who is the doctor
PW14, my lord.
ଡକ୍ଟରଙ୍କ ପାଖରେ ମଧ୍ୟ ପ୍ରଡ୍ୟୁସ୍ ହେଇଛି ଡକ୍ଟର କହୁଛନ୍ତି it is possible by such weapon.
It was produced 1 month after, lordships. 1 month after. Police seized lord 3rd May, my lord.
କଣଟା
MO was produced before the, my lord, 1 month after, lordships.
it's all right you and nothing has been brought out in the cross examination of PW11.
Yes,
You
sir.
see, the evidence is very clear. I was taking rice. My grandmother, that means perhaps the deceased, she was preparing sago. By that time, accused dealt axe blow on the neck of my maternal grandmother, and she fell down with the severe bleeding injury. And chhatpot heutila. I ran away from the spot out of fear. And after hearing the so-and-so, came to the spot. କିଛି ଜେରା ନାହିଁ ସଜେସନ ଟିକେ ଦେଇଛନ୍ତି ଆଉ କଣ 2-3ଟା ପ୍ରଶ୍ନ ପଚାରିଛନ୍ତି ଏଇ evidence coupled with the doctor's evidence
Yes, my lord.
so
It's a minor girl, lordships. 9
he
years
minor
old. 9 years old, my lord.
କଣ
He is 15 years.
No,
15 years student
my lord,
ପଢୁଛି
reading
exam
class 4, lordships. He was reading class 4.
class 5 ତ ଲେଖା ହେଇଛି and
5 ହେଲେ ବାଚ୍ଚା 9 ବର୍ଷ, sir.
whatever no can the evidence of a witness who is aged about 15 years and deposed against you to be the eyewitness to the occurrence will be discarded merely because she was 15 years of age unless you bring out something
My lord.
that yes she has been tutored or something like that or evidence is otherwise not believable because child witness are competent witnesses in
Yes.
view of section 118 of the evidence act
Yes, sir.
if
15
they
years.
give the rational answers to the questions and
he has also not been shown as a child witness.
uh,
Yes,
So
15 years so he is
at the time of occurrence, I was just staying in the house of my lord and reading class 4, lordship. That's why. Lordship, so far the PW7 is also, my lord. The accused was a psychiatric patient.
PW7 कौन हला
She's a cross case. The accused was a psychiatric patient. He was under medical treatment, lordships.
substantive.
That
No, anything, any other thing is there in the record, Mr. About any treatment has been provided, anything?
No.
Because this PW.
There is nothing. Only PW7 statement is
ନାଇଁ
loss exam. Loss
ଆପଣଙ୍କର
examination.
ସେ ଜେଲରେ ରହିଲାଣି ନା 9 ବର୍ଷ ପାଖାପାଖି
I'll take instruction.
ସେମିତି କିଛି ବାହାରିଛି କି ସିମ୍ପଟମ୍ସ?
ନା କିଛି ତ ଲେଖା ହେଇନି।
ଆଚ୍ଛା, ନାଇଁ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇଯାଆନ୍ତୁ ଆପଣ। ଆଉ we'll take up this matter on 15th and take instruction. And apart from that, this custody period and also criminal antecedent, all right? The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 3/5/2015. And he placed the evidence of PW7, which indicates that the petitioner was having psychiatric problem and he was under medical treatment. Let the learned counsel for the state obtain instruction about the health condition of the petitioner to the concerned jail superintendent and also produce the custody certificate along with the criminal antecedent, if any, against the petition. This girl must be also staying ଏଇ ଯୋଉ 11 ନମ୍ବର ସାକ୍ଷୀଟା ଯିଏ ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ କହିଲା ସେତେବେଳେ ତାକୁ 2017ରେ 15 ବର୍ଷ ହେଇଥିଲା। ସେ ସେତେବେଳେ ଆପଣଙ୍କ ଘରେ ମଧ୍ୟ ରହୁଥିଲା, 4ର୍ଥ ଶ୍ରେଣୀରେ ପଢୁଥିଲା କହୁଛି। ବାହାରିଲେ ଆପଣ ତାର ଲାଇଫ ପ୍ରତି ମଧ୍ୟ ଆଚ୍ଛା ଲେଖିଲେ ଆଉ ଗୋଟେ ଆଣନ୍ତୁ instruction about the family background of the petitioner. So also whether the sole eyewitness PW about the status about the status of the sole eyewitness PW11. Hello? Okay. Matter to be listed in the week commencing from 15th July 2020.
Item 18.
My lord, kindly pass over the matter. One pass over. My senior is coming.
For the informant, last time I also played the same prayer. See, quick question have been released and I'm placing my lord.
These are the hard killers.
No, my lord.
Wait.
They
You have not obtained. You want to obtain the instruction about criminal antecedent. All right. IA number, this is CRLA number 780 of 2019. IA number 1708 of 2019. This is an application for bail. In this matter, who is there?
My lord, in the first case, I am 780.
Acha.
I am for the appellant,
Hard
Ramesh
Mr.
Reddy.
Hard Mr. S.K.Sahoo and counsel appearing for the petitioner. Mr. J. Katkia, an additional government advocate. Mr. H.S. Misra,
For the informant.
for the informer. Land counsel for the state seeks some time to obtain instruction about the criminal antecedent, if any, against the petitioner. Put of this matter. 15 तारीख रखला हो.
My co-appellant, 3 have been released on bail.
15th of July 2024 and same order to be passed. Upon एटारे की अछंती 649 ने
On behalf of Mr. Dayanand Mahapatra.
Same order 1463 of 2019 application for bail, similar order to be passed. ये जो IN number गुड़ाक अच्छी जो stay of realization of fine, that is to be passed, that stay realization of.
Another thing, my lord, I pointed, I have given the copies of the bail order of the co-appellants. So I have already served. So that 3 co-appellants has been released on bail, 10 years in custody. I have already served the copy of
The learned counsel for the petitioner, data like the CRLA number 780, has served the bail order copy of the co-accused persons to the learned counsel for the state.
already served.
I'm giving it.
And
I
also
have the copy. I'm giving it.
requisition copy भी दी थी.
These are all the copies I have given.
हाँ.
Okay, give it. In court, the learned counsel for the state shall also examine the claim of parity. Mr. Fatkia, से जो 3टा bail order देखो claim of parity का exam.
Also the deposition.
ठीक है से तो मना करना 15 तारीख आसीबो.
And also there is a custody period.
Custody certificate. Custody certificate आपने देखी जाओ 8 पर्यंत. 15/7 आसीबो. Custody certificate. Stay of fine allowed. है ना? Both applications. Yes.
Item 19.
In this case, my lord, on the last occasion, your lordship passed an order to take instruction from the petitioner, my lord. After several attempts, my lord.
Just a minute.
My lord.
So now what is your instruction?
My lord.
What is your instruction now?
A meeting was arranged to contact the petitioner, my lord, but due to technical difficulties, it could not be taken place. So, another.
You want to contact the
my
counsel?
Lord.
Sorry, the accused.
Accused, my lord.
Why you say that it is not possible? You can, if you want, the court can provide you the opportunity.
My lord. In the meantime, a soft copy may kindly be provided, but
you are to give your pen drive. Just there is no problem.
Last time order was there.
The order is very clear.
May I be permitted to take in my email, my lord?
No. You give a pen drive so that we can take it.
Give the pen drive. Entire things will be supplied to you.
Okay.
Number 1. Number 2. If you want to have a talk with your client, who is in which jail he is?
Jharkhand, my lord.
So the registry will provide that opportunity. It can be given to you. There is no problem. Okay.
Okay, madam.
Arrangements can be made. You can have a talk with him. He is in Jharpada jail, na?
My lord.
Very easy. There is no problem. We are directing Register Judicial. If you appear before him and make a request, he will make the necessary arrangement.
Okay, madam.
All right.
Yeah.
And counsel for the state submits that is not having the any documents to move the application for bail. We have already passed an order on 19/6/2024. Answer submission. And if the petitioner provide the pen drive, the necessary documents shall be supplied to him. And stop. The London Council submits that he wants to have interaction with the appellant who is now in sub-jail Bhubaneswar. If any such request is made by the petitioner's counsel appearing before the registered judicial, necessary arrangements have been made in that respect. So we are fixing the case to 15th of July 2020.
My lord.
Put up this matter on 15th July 2020. You provide that pen drive so that it will be supplied to you.
Okay, my lord. Obliged.
Item 20.
Hey, but in this case, item 20 pass over, item 21 ta kari. 21 is also my case.
Pass over for the day or you
Tomorrow,
want
madam.
tomorrow?
Madam. I'll ask you.
Okay. 2nd July. You want to move item number 21 today?
Madam.
It's a JCRLA 99 of 2019. How many appellants are there?
Only one appellant, madam. Appellant convicted at 302 IPC.
Just a minute. Damayanti Soren, is she a lady?
Lady, my lord.
Okay.
Relationship of the deceased mother.
Huh?
Relationship of the deceased mother. One mother.
ମାନେ
ଝିଅ।
ମାକୁ ଝିଅ ମାରିଛି।
My lord, in this case, two accused persons. Charged Damayanti Nare 302, 34, 114, 372, Indian Penal Code. Principal accused Nare 302, 372, 34 IPC. But during trial, principal accused acquitted. Bhagavat.
You come to the sentence where it has been mentioned that you have been found guilty under 302 and imprisonment for life. So also you are directed to pay fine of rupees 10,000. Okay. So what is the name of the deceased?
Name of the deceased, my lord, Sunita.
Sunita Soren.
Sunita Soren, my lord.
And how you are related to the deceased?
Mother, my lord.
You are the mother or she is the mother?
She is daughter, my mother. My appellant is a mother.
Okay.
This is a daughter.
So the deceased is the daughter of the appellant.
My lord. Custody, my lord.
Just a minute. What is the date of custody?
16/3/2015. About 9 years above.
So, is it a case based on direct evidence?
No, my lord.
Circumstantial evidence. So, what are the circumstances?
Circumstances, my lord, the only hostile evidence, PW5. PW5 says, I know the informant both.
We say that what are the types of circumstantial evidence appearing on record?
Circumstantial evidence, my lord. The evidence of the ରାତି 2ଟାରେ ସେ ଅନ୍ୟ ଝିଅ ତାର ଅନ୍ୟ ଲୋକ ପରେ ସହିତ ଯେ ଡେଜର୍ଟେଡ୍ ବାଇ ହର ହଜବେଣ୍ଡ ସ୍ୱାମୀ ଛାଡି ଦେଇଛି ଝିଅଟା ତାର ପଡୋଶୀ ଘରେ ଶୋଇଥିଲା ସେ ଆଣିକିରି ୟା ସାଙ୍ଗରେ ପଳେଇଲା ପ୍ରିନ୍ସିପାଲ ଆକ୍ୟୁଜ ସାଙ୍ଗରେ ଭାଗବତ ମୁର୍ମୁ ଦିସ୍ ଇଜ ଓନ୍ଲି ଲାଷ୍ଟ ଥିଓରି ଅନୁସାରେ କନଭିକ୍ସନ ହେଇଛି नो आई विटनेस नो डायरेक्ट एविडेंस नहीं 302 रो
PW5 रो एविडेंस को बेसिस रे कन्विक्शन
दैट इज आल्सो होस्टाइल विटनेस
जस्ट अ मिनट लेट अस सी दैट About a year back, the deceased was sleeping with me. In the dead hour of night, accused Damayanti Soren came to my house and it took the deceased with her. On the next day, I learnt about the death of the deceased.
Judgment para 6 ro last person mela.
Para 6
On entry,
Para
the
6
accused
judgment. So judgment. The last but 14 line minor. PW5 to their house in the late night and at 3.
कोटा पुडुचंदी
Para 6 ro.
हाँ
Last but 15 minor.
Para 6 रो let me start with the evidence 8 तो छी Para 6 रो
Para 6 ro pura last. last portion ro 15 line upruku PW5 to their house in the late night, and at 3 a.m. Damayanti went to the house of Punnendu and informed about the death of the deceased. On being asked, she disclosed the death of the deceased due to bleeding from her private part.
PW5 ର ତ evidence ଆମେ ପଢିଲୁ
My lord.
place କଲେ
My lord.
ସେ PW5 has been declared hostile and she has stated that he was sleeping with the deceased, and in the night this appellant came and took the deceased with her.
My lord.
And then she subsequently learned. Then whatever thing has been stated, he has stated no. Then I have not seen who killed the deceased. So this is the only evidence or anything else?
This is the only evidence, my lord. In the cross-examination, I have not seen
No, that we have seen.
who killed the deceased. I also cannot say as to how the deceased died.
The court has not discussed about the circumstances. What are the circumstances? Circumstantial.
The burden of proof, my lord, para 20. As per this 101 of the Evidence Act, prosecution has to prove its case. In the present case, the link in the circumstance as per the last seen theory has been well established by the prosecution. Hence, burden lies with the accused, Damayanti, to explain the fact which are within his knowledge as mandated under section 106 of the Evidence Act. She has failed to give any satisfactory evidence as to the death of a deceased within very proximate time of her talking the deceased and time of her death. Thus, the intermediate material have been put to her while as she has
केबे dead body मिलला?
Same tomorrow, just
Next day morning.
24 hours ଭିତରେ postmortem ହେଇଛି.
No, କୋଉଠି ପଡିଥିଲା dead body?
He disclosed the fact of death of Christmas very morning, the informant as well as the others. Within a short span of time, the deceased met with the.
What is the motive behind the commission of crime? Has anybody stated about the same? Why?
Maximum witness says he's a deserted lady. ये हांडिया खाइथिला खाली
किए खाइथिला
अपीलेंट मैन ट्राइबल मैन आदिवासी से आड़ी खाली देई देला झियो को आनी कि ता संगे जाईची नोबडी कैन सीन डेथ
2015 ରୁ ରହିଲେଣି
माय लॉर्ड 9 इयर्स अबव
ଆଉ ବେଲ ଯାଇ ନଥିଲେ
ବେଲ ଆମେ ଯାଇନୁ ଆଗରୁ ଏଟା ଜେଲ ଅଛି
ଆଗରୁ ରିଜେକ୍ଟ ହେଇନି ଏଠି ହାଇକୋର୍ଟ ରେ
ଫାଷ୍ଟ ଆପ୍ଲିକେସନ
ହଁ ନାଇଁ ଏଠି ହାଇକୋର୍ଟ ରିଜେକ୍ଟ ହେଇନି ତ ଦେଖିଲେ ଜେସିଆର ରେ କିଛି ଅର୍ଡର ଅଛି କି नहीं मेन accused acquittal ये खाली 302 रे मार्क ए conviction करছে are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner is the mother of the deceased, Sumita Soren, and she is in judicial custody since 16/3/2015. She is the mother of the deceased Sumita Soren. Yeah,
Sunita.
Sunita na Sumita? Sunita. And the case is based on circumstantial evidence, mainly on the last scene of the petitioner in the company of the deceased, which has been deposed to by PW5, who has also been declared hostile by the prosecution and has stated that he had not seen who killed the deceased. Land Council further submits that there are no other clinching evidence on record, and the good chances of success of the appeal and balanced convenience is in favor of the petitioner. And even though paper book has been prepared, but there is no chance of early hearing, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and placed the evidence of PW 5. Considering the submission made by the learned counsel for the respective party, nature of evidence adduced during trial, absence of any direct evidence, period of detention of the petitioner in judicial custody, we are inclined to release petitioner on bail allowed.
Item 22.
May I please it, my lords? The sole appellant, he was convicted on section 302 of Indian Penal Code.
Yes.
And he was taken into custody on 7/8/2016. It is a fact that he was not on bail during course of trial.
7/8/2016.
Well,
And what is the conviction?
Conviction life imprisonment with fine, 300.
Of offenses are?
Offenses charge was framed on section 498A, 304B, 406, read section 4 of the DP Act along with 302.
Okay.
All other charges he was acquitted.
Okay.
This is the wife of the present appellant.
What is the name of the deceased? Mamata Rani? Husband, petitioner.
Mamata Rani is fine, my lord.
How many years of marriage the occurrence took place?
FIR টা দেখবেন
12/6/2015
12/6/2015
date of deceased Psychiatric
Acha, within 1 year.
and occurrence said to have been occurred on 5/8/16, my lord.
Date of occurrence 5/8/2016. Where she died and what is the cause of death?
Cause of death is a caught injury on the neck of the deceased. Just I am saying that the case is based on circumstantial evidence.
Yes.
There are two circumstances which was relied upon by London trial court, that is last in theory and leading discovery of the weapon of offense as per the provision of section 27 of the Evidence Act.
What is that weapon?
Pottery.
Okay.
And the nature of the evidence, I would like to say, the deceased had been to her parents' house. The appellant went there. They both left the house in the midday on the ground that the deceased will be medically checked because she was
Pregnant.
Thereafter, in the night itself, in the Bazaar area, two witnesses saw the deceased along with the present appellant. And thereafter, neither the deceased returned to the house nor the appellant went to his in-law's house. On the next day morning, the deceased was found lying on a roadside with a cut injury. So there are two witnesses who said regarding the last scene theory.
They have not seen any weapon in your hand?
No.
Okay.
They were moving in a scooty.
But what is your statement in the accused statement that when you left the company of your wife, have you admitted that you were present with your wife And if so, when you departed from the company and how
Some-
she died?
Some facts regarding leaving the house that is admitted. They were in company that was admitted. Thereafter, the appellant says that I left my wife on the way and proceeded to my house. That was the case. That defense, I think, that not properly taken. I will not go to that defense itself at this stage. My humble submission would be that in view of the detention period that is from 2016, and there is no motive at all to commit the murder of the wife. He may be released on interim bail for
So why she was residing in her father's place? Have they stated any dissension between the two?
Initially, that was the story, but ultimately, in the evidence, that was not established.
That was the reason why you were acquitted of the charges.
My
under
lord.
498.
Initial story was that there was some dissension regarding demand of dowry. So, out of torture, the wife went to her father's house, but that was not established during course of
So now the case is based on
circumstantial evidence.
evidence.
Two chain of circumstances. One is last seen theory, another is leading to discovery. So, for the leading to discovery, I am not saying here. Actually, one of the constable who was examined is not a witness to leading to discovery. He said that the weapon was recovered during course of investigation, thereafter leading to discovery. However, that was not.
Okay, that is to be seen.
Only best material is the last seen theory. That is the.
Let us see your accused statement.
Accused statement, your lordship may turn to page 97.
Paper book.
Paper book. Last କଣ କହିଛି ଦେଖ
Last question. Oh, you come to the question number 45.
My lord, my
That
lord.
is, ଆଉ ବାକି ସବୁ ନାହିଁ ଆଜ୍ଞା ନାହିଁ କହିଛି ସେଇଟା ମୁଁ ମାରି ନାହିଁ ବା କଣ ମିଛ ଚାର୍ଜସିଟ୍ ଦିଆଯିଗଲା ମୁଁ ଭଉଣୀ ଘରକୁ ଯାଇଥିଲି
ମୁଁ 1/8/2016 ଦିନ ମୋର
1/8 ଦିନ ଓ 6/16 ଦିନ ଫେରିଲି ମୁଁ ମୋ ସ୍ତ୍ରୀକୁ ମାରି ନାହିଁ
7/8/2016 ଦିନ ମୋର ସ୍ତ୍ରୀର ମୃତ୍ୟୁ ହୋଇଛି ଶୁଣି ମୁଁ ଅନନ୍ତପୁର ଆଉଟପୋଷ୍ଟକୁ ଆସିଥିଲି ସେଠି ମୋତେ ଆରେଷ୍ଟ କରାଗଲା. That means he denied things and said that I was not present, not took the decision along with me. That was the denial plea, my lord.
So when this judgment was pronounced?
Judgment was pronounced in the year 2017 perhaps.
Date of judgment
16/12/2000.
Mr. Sorachandra Mahapatra, land senior advocate appearing for the petitioner and land counsel for the state, submitted that the petitioner is in judicial custody since 7/8/2016. The petitioner is the husband of the deceased, Mamata Rani Swai.
A lot of PW line on the last para. PW line on the judgment, my lord. Running page 29. Running page 48, sorry, my lord. Judgment para 20, judgment page 29, PW9, my lord, on the last.
Oh, that is, they have stated about the last scene. He's staying.
I have
On the next day morning, they search of them on the last scene and found the dead body of the deceased, which was laying on the side of the Ichapur Dasbatia road.
Kota.
The last person. They could not
lying
get
by the side of Ichapur Dasabatia Road near Keruapada with bleeding injury.
That I have stated.
The statement of PW9 also stated that on the last scene with them.
The Land Counsel for the petitioner submitted that the petitioner is the husband of the deceased, Mamata Rani Swain. And the marriage was solemnized in the year 2015. And the death took place, the occurrence in question took place on 5/8/2016. The case is based on circumstantial evidence. And there are two circumstances, that is last scene of the petitioner in the company of the deceased and leading to discovery of the weapon of attack. The Land Council further submits that though the petitioner was charged under section 498A, 304B, 406 IPC and section 4 of Dowry Prohibition Act, but the Lennon Trial Court has acquitted him of all such charges and found him only guilty under section 302 of the Indian Penal Code. And the petitioner and the prosecution has failed to prove any motive
Motive is proved, my lord, as per the statement of PW5 and 6, my lord.
What is that motive?
Motive, my lord, have a glance on the statement of PW5, my lord.
What is the motive?
On para 2, my lord, the accused used to torture the deceased physically and assaulting her, saying that let her go to out.
Are you
so
not
that,
following the argument advanced? Your case is that she was subjected to torture,
my lord,
cruelty. The London Trial Court has acquitted the accused.
Acquitted 304B and 4DP Act, my lord, and 498.
Also 498A.
My
That
lord,
means that
based
charge
upon the
has been
302, my lord, motive is proved, my lord. She
Those
wants
are
to
the-
marry another girl, my lord.
Mr. Counsel, according to you, these are the reasons for which the murder has been committed,
My lord.
for which the additional charges were framed, 498A, 304B. Your case is that it was on account of dowry. It was a case of dowry death, but there was demand of dowry. On account of demand of dowry, there was torture, and that related to the motive or behind the commission. That has been disbelieved by the trial court. This 498A30. What additional thing you want to say that apart from those demand of dowry, there was also a relationship of the petitioner with any other girl?
No, the deceased was not the choice of the accused. That is the evidence. PW5. Yes, that is one of
the Land Counsel for the the Land Counsel for the petitioner submitted that in view of such acquittal of the petitioner of the other charges, the prosecution has failed to prove any motive behind the commission of the crime. And the discovery of the weapon at the instance of the petitioner is also a doubtful feature, in as much as it appears from the evidence on record that the weapon was already discovered by the time the statement of the accused under section 27 of the Evidence Act was recorded. Therefore, it cannot come within the scope and ambit of such section. It is submitted that on the basis of last seen evidence as adduced by the prosecution, it is very difficult to sustain the charge under section 302 IPC against the petitioner, and there are good chances of success in the appeal, and balance of convenience is in his favor, and therefore the bail application may be favorably considered, particularly when there is no chance of hearing of the appeal in the near future. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that even if the prosecution has failed to establish the other charges, but there are evidence on record which indicate that the deceased was not the choice of the petitioner, and the petitioner was having relationship with another girl, and that might have been the motive behind the commission of crime. It is further stated, further argued by the learned counsel for the state, that when the last seen evidence has been proved by the prosecution and the petitioner has not offered any explanation in his accused statement as to when he left the company of the deceased and how the deceased was found lying dead with hot injury on the vital part of the body on the roadside. It is a very clinching evidence against the petitioner. Considering the submission made by the learned counsel for the respective parties, in view of the nature of evidence adduced by the prosecution, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody, as well as the ratio laid down by this court in the case of Leti versus so and so, we are inclined to release the petitioner on interim bail for a period of 3 months. And while on interim bail, he shall not indulge in any criminal activities, and the learned counsel for the state shall produce the report from the IIC of Palikuda police station regarding the conduct of the petitioner while on interim bail.
My lord, I mean, pardon to say,
yes,
but the fine was not stayed earlier, it may be stayed. Otherwise,
let us see that order.
Order of chief. Fine stage.
Fine stay.
It was already stayed.
On 4/8/2020.
It is stayed
it was already stayed.
4/8/20. Next.
Okay.
Item 23.
May I please, my lord, on behalf of Mr. R.K. Mohanta, kindly warn a capital.
All right. A mention is made on behalf of Mr. Rajiv Kumar Mohanto to adjourn the matter for 1 week. You want it to be on 8th or 15th?
15th.
15th. This matter on 15th July 2024. Yes.
Oh, bless my lord.
Both of the matter, my lord, adjourn.
This matter is to be listed along with JCRL and number 25 of 2018. Ochi to tar sange raho. Yes.
Item 24.
Oh, bless my lord.
24. Officer served me a copy of judgment, my lord. But here I found that there is nothing regarding bail and interim and real estate fine. That is
what do you want?
My lord, I need that printed paper book as well as my lord the petition's copy also.
No, it's all right. Why don't you? Paper book has not been prepared, Mr. Das.
Yes, my lord.
If you want the entire trial court record,
Yes, my lord, that will
provide a pen drive. It can be given to you.
Yes, ma'am.
Okay?
Yes, ma'am.
The court master can give
I'll
you.
take, ma'am.
You and you want to move this bail application next week or a week after?
Next week, maybe after 9th, ma'am. Next week,
No,
10th.
we'll list it on 15th.
Obliged, ma'am. Highly obliged.
The learned counsel for the petitioner submits that he may be supplied with the photocopy of the trial court record. Let the learned counsel provide the pen drive to the court master, who will provide the same to him. Put up this matter in the week commencing from 15th of July 20.
Obliged, ma'am.
Item 25.
Mr. Jafrullah, a petition has come from jail for your engagement in this case. So you are to file a Bhinama. Have you got that Bhinama? You do not know this man?
No, yeah, he has written letter.
Pradeep Malik Pujel Rachi Baripada.
Is one of the relation.
Sir, you when the prayer has been made, he has not sent the Bhinama. So why don't you obtain a Bhinama so that he can sign it and file it in court? Peruse the prisoner's petition received from Circle Jail Baripada at Flag X, wherein prayer has been made for engagement of S.K. Jafrullah as his advocate in place of Mr. Chittaranjan Sahu. Mr. Jafrullah is present in court and submits that he is not having the Bhinama. Let the learned counsel for the state obtain the Bhinama from the appellant, who is now in Circle Jail Baripada, and so that it would enable Mr. Jafrullah to file the same, put up this matter on 15th of July 2024. Free copy. नहीं, ये prisoners petition আসছে Circle Jail Baripada 2024 ରେ ଆସିଛି මේ ମାମଲା इसमें भी ट्रांसफर ହେଇଯାଇଛି
Return the copy.
Item 26.
This matter relates to conducting photography in the Konark temple. We are the licensee under the ASI, my lord, to conduct photography. This writ appeal has been filed by the outsider who claims to be the having license from the state government. State government refused to say that nobody has been issued with any identity card. That was the matter. Learned single judge order is under challenge. I filed this application, interim application, for appropriate order because an interim arrangement was made till filing of the affidavit by the ASI. ASI filed affidavit saying that since it is implemented throughout India, 3,600 and some odd institutions are being operated by virtue of that notification 2017 and 8, which is under challenge. 17-18, a new guideline has been advertised by the ASI.
What guideline came?
For conducting photography throughout all the monuments throughout India. That is under ancient monument rule, my lord. That was under challenge. Learned single judge says no.
What are those guidelines?
Those guidelines are they have to have some certain of qualification, minimum matriculation, track record, criminal record. Those has to be seen, and they have to face an interview. That we have faced and we have got the license. Now some outsiders, those who claims to be we have got the identity card from the state government. Thereafter, state government clarified that nobody has been issued with that. Collector has reported that those are without any basis. So otherwise it is fake. Now that affidavit has been filed by the ASI. ASI says it cannot be considered on one-time basis because throughout India, 3,600 institutions are being implemented. My Lord Justice Das was hearing
along with Justice and the Chief Justice, that matter. Your Lordship's order for interim arrangement, now they are creating problem. Now ASI said, no, this cannot be one-time basis, this cannot be relaxed. You have to get a license.
What interim order has been?
An interim order to regulate those 154 unauthorized entries till a final decision.
Where is that order? When
that order, they at 20 order dated 28/9/2022.
Copy was served just now.
This which copy, Mr. Wali?
IA copy
is placing. Just a few minutes ago, it was served on.
IA number?
Not even numbered.
New IA. The last IA.
Second IA, which is not even numbered.
No, yes, it is numbered.
Numbered.
It is numbered.
Is it
4569?
4569.
At flag 5.
Yes.
456.
It is filed for recalling the order dated 28/9/2022.
Yes, my lord. Because
it has been filed by whom?
By we are the licensee photographers.
No,
interveners. We are the interveners.
So it has been served on the petitioner when I am appealing for the petitioner just few minutes back.
Okay.
Just that. I need some time to go through it. One.
All right.
But the only purpose to matter should be heard finally. That was the purpose.
Now
the Lordship may post the matter to next week. Otherwise, unnecessary creating problem.
Then, if you say that is your purpose, then we will dismiss this interim application and fix a date for hearing.
And let it
You
be
are
live.
filing it for some other purpose.
Well, let it be live.
Why
They are creating problem. They are. I'm constrained.
ଆପଣ କହିଲେ ରିଟ୍ appeal ଟା ଶୁଣାଣି ହବ
I'm constrained.
ଆମେ ଗୋଟେ ତାରିଖ ଗୋଟେ ଧାର୍ଯ୍ୟ କରିଦବୁ ଏଇ interim application ରେ କାଇଁ ଅଯଥା
I'm constrained.
ସମୟ
Let
ନଷ୍ଟ
it be
କରିବୁ
live. Let my learned senior file their objection, whatever he wants. Let it be live.
ଆପଣ ଚାହୁଁନାହାନ୍ତି merit ରେ ଶୁଣାଣି ହବ
Merit ରେ ମୁଁ ଚାହୁଁଛି ଶୁଣାଣି।
ଆଉ ସେ ତ ହେଇଯିବ
ସେଇଟା live ରେ ଥିଲେ କିଛି ଅସୁବିଧା ହବନି।
Your Lordship permits you. Final hearing was also your Lordship's Honorable is also addressed at length.
Yes.
Yes. At length on one day. Matter was heard more than an hour. Then it was posted that the Honorable Court needed the assistance of two Supreme Court judgments.
Kind minutes of the Honorable Chief Justice there. Kind minutes of the Honorable Chief Justice.
ଠିକ ଅଛି ଠିକ କହୁଛନ୍ତି ସେ କଣ ଶୁଣନ୍ତୁ ଆମେ ଏଟା ଫାର୍ଷ୍ଟ ଟାଇମ ଲିଷ୍ଟ ହେଇଛି ଆମେ so yes.
To produce a couple of Supreme Court judgments, at least one Supreme Court judgment, which would give some traction. So that was all. It was like virtually it was like a part-heard matter. I leave it to your Lordship. If your Lordship wants to hear it, I just need some time to again get ready.
Mr. Palith, perhaps the Honorable Chief Justice has sent it to us or something like that. That is how the flag 6
minutes.
I was not aware of that.
That is at flag 6.
Very well then, my lord.
It is just the order is that it should be placed before a division bench where my brother is a member. So that is how it has come.
Maybe because of this IA. Because of this IA, it was that was. My lord, I'll argue this matter at length.
What do you, on consensus we can fix a date?
Yes.
So that it can be hard. Why? What we are why unnecessarily waste our time on this interim?
Any day convenient to my lord.
Tell a date. Both you are there. All of you are there.
Convenient to my friend. Any day next week as per my friend's conveniency.
No,
because my
we
friend
are
is senior
hearing death reference cases. We are giving preference to those cases.
Next Wednesday.
So
Wednesday.
No, tell us that we commencing from 22nd. On any date, a particular date, it will come in the supplementary list, so that it can be hard on that.
May pray on 18th. Can it be possible?
Mr. There are two death reference cases now before us. We have to finish those two death.
Then 22nd, as my lord.
Tell us a particular date.
22nd, my lord. No problem.
Mr. Pali.
24th.
Monday ଆସିଲେ ଟିକେ ଭଲ ହୁଅନ୍ତା
Monday
ସପ୍ଲିମେଣ୍ଟାରୀ ପୁଣି ପଳେଇ ଆସିବ ପୁଣି ଅସୁବିଧା ହବ ମାଟର 2 PM ଫିକ୍ସ କରିଦେଲେ
ଆପଣ ପରା କଣ ସେଠି ଏତେ ସମୟ ଆର୍ଗୁମେଣ୍ଟ କଲା 2 PM ରହିଲେ ସରିବ ବୋଲି ଭାବୁଛନ୍ତି
ସରିଯିବ
ସରିଯିବ
I am equipped by your lordship's judgment.
We are all equipped by some judgment.
Acha, okay, so let it be then listed on 22nd.
Yes.
And this IA is not phrased.
Let it be live. I will be messaged. Let me, my friend. for some purpose.
22nd, and there's a part third matter I'm to argue. Any day, minute that week, if it's communal.
23rd also.
23rd also. 23rd.
So, pardon in that case, Miller, because I am one of the stakeholder, Miller. I am appealing on behalf of the one of the intervener, Miller. Intervener is the Photographer Association, Sun Temple Photographer Association, which has been established since 1984, Miller. My application was already there, Miller, in the last list, but it was not here before.
Intervention refused.
Now, in the footnote, my application has not been listed.
What is that IA?
My application, my case number is IN number 987 of 2024.
आपण कोउथरे फाइल करथिले IA टा
मोटा टॉप केस टर कर दिए
ए जो W रिट अपील ले फाइल करथिले रिट अपील ले फाइल करथिले व्हाट इज योर IN number?
My number is 987 of 2024. It was already in the previous list, Miller, but today's date it has not been indicated.
ए कोन डिस्पोज पे ही छी
Not dispose of pain.
That is probably still pending.
So that is an application for intervention.
It was,
and you have supplied the copies to the all the learned counsel.
On the last occasion, it was not entertained since my friend has insisted, but it was not entertained because they were not party in the writ petitions. No, there was nobody in that this matter. If at all they are agreed,
पचाउथुलु किछि सेटा रिजेक्ट ही
again, no, reject ही नहीं, but it was not entertained
My learned friends land
by the present Chief Justice. It was not entertained. And if at all they are agreed,
you get prepared on merit.
Yes.
Because we are fixing the date. On that day, we can pass the order and also hear you on merit what
Yes.
is there.
Grateful. I am grateful.
Get the registry meter for listing of this IA meter.
अच्छा नहीं we are ଆମେ ଖାଲି ଦେଖୁଛୁ ଯେ କାଳେ ସେଟା dispose of ହେଇ ଯାଇଥିବ ସେଇଥିପାଇଁ
ହେଇନି
Last occasion order था 25th ଥିଲା 25th last order
ଆପଣ ଏଟା 2014 ର IA ଟା ତ
ନାଇଁ ଏଟା 24 ର ସାର୍
ହଁ 2024 just में 2024 ର ଦେଖିଦେଲେ ଜଣା ପଡିଯିବ
ନାଇଁ 25th ରେ list ହେଇଥିଲା 25th
ଏଟା 987 ଟା ହଉଛି ତାଙ୍କର 987
just
last order ଟା ଦେଖି ଦିଅନ୍ତୁ dismiss ହେଇଛି no order it has been passed rather I was assured by the
just a minute just
your matter will be hard at the time of hearing
see IA ଟା
at the time of hearing
see ଯୋଟା IA ବର୍ତ୍ତମାନ ସେ କହୁଛନ୍ତି
not Sadasi
okay first ଲେଖନ୍ତୁ IA number 987 of 2024 this is an application for intervention filed by
the Sun Temple Photographers Association
Guide and Photographers Association, Sun Temple, Konark. The learned counsel submits that copy of the interim application has been served on the counsel, and the matter may be listed along with the writ appeal on the next date. Stop. Writ appeal ta lekhantu. Acha out IA lekhantu. IA number one. So this is an application for recalling the order dated 28/9/2022. Mr. Palith, land senior advocate, appearing for the appellants, submits that the copy of the interim application has been served on him in court today, and he intends to file objection to the interim application. The learned counsel appearing, the learned counsel who has filed the interim application for the recalling the orders dated 28/9/2022 submits that if the matter is hard on merit, then he may not insist on pressing this interim application. All the learned counsel agreed that the matter may be taken off any time in the week commencing, any date in the week commencing from 22nd of July 2024 for final hearing. In view of such submission made by the learned counsel for the respective parties, list this matter on 23rd July 2024 with IA number 987 of 2024.
One last submission, my lord. I am in the tide of writ petitions, my lord. Initially, that
That
was
will come along with
yes,
it.
what humble submission, my lord. In that writ petition, that prayer was challenged that the capping of the numbers of the photographers in the Konark temple that was never addressed before any other writ petitions, my lord. That's what a specific direction from this honorable court, order number 2, dated 17/5/2023, that is also reflected in the cause list, my
No,
lord.
it is mentioned that it's a single bench matter.
Yes, my lord. It is mentioned, my lord.
Just a minute.
The last noting is, my lord, the opposite ASI had not filed counter, my lord, because
No,
that is to be addressed.
we'll send it to the single bench. Why it will be adjudicated in a writ appeal?
Yes, my lord.
Because no order has been passed. Say
Because, my lord, here, my lord,
any judicial order has
yes, my
been
lord, I want
passed.
to bring your lordship's notice. The honorable single judge protected me. Thereafter, when it came to the notice of the honorable single judge, the honorable single judge pleased to pass that the matter stand adjourned with a direction to the parties to make a mention for listing of this case, subject to, however, ultimate outcome of the writ appeal. Here, my lord, the interveners are mentioned, and this matter was tagged up with this writ appeal, my lord.
Should I mention your matter?
Yes.
Why should I mention your matter?
My numbers were mentioned, my lord.
It's all right.
It is on your mention.
No, no.
You are physically present in the court and you mentioned my matter be tagged.
So it's all right.
What are you saying,
this,
Mr.
this is to be heard by the single bench,
My lord,
right?
the lordship may inform several writ petitions are being filed before the single judge. Single judge passed interim protection order in favor of the applicant. Subsequently, this writ appeal filed before this honorable court.
You see, once the writ appeal, if the issue is same, just if the issue is same and it is decided in the writ appeal, then that will ultimately govern all the single bench matters. But why a single bench matter will be heard by us?
Yes.
If we dispose of writ appeal, then that will obviously, unless the order is challenged in the higher forum, okay. WPC number 1156 2023. The registry has mentioned that it is a single bench matter. Put up this matter before the assigned bench.
My lord, there are two writ petitions, my lord.
Second also say, yeah.
Yes, 11595 of 2020.
Put up this matter. Say second number, WPC 115950. Okay.
Highly obliged. Highly obliged.
Grateful.
Grateful.
Item 27.
Please, my lord. My lord, here the petitioner is languishing in jail custody since 21/3/2016.
Yeah, just.
Sir.
Mr. Sahu, you are for?
Petition number 2 to 7.
Okay, there are number of appellants.
Yes,
Okay. Let us see that how many appeal has been filed by
one
7.
appeal has been filed. Prisoner petition is sent by the one Dambrudhar Bhatra for one.
Dambrudhar is appellant
One.
for one.
For
I am appearing. I am appearing.
Okay, just a minute. Mr. Panda for A1 and Mr. Sahu for
Jugal Mahanti is appearing for one. Jugal Mahanti. Jugal Gita Raut. For appellant number 1.
Appellant number 1 ta na hochi
Dambrudhar Bhatra ta pai Jugal Raut is appearing.
Yes.
Acha. So not Mr. Panda.
No, I am on behalf of Mr. Jugal Raut.
Both. ठीक है. So you are appearing for
the rest. Yes, ma'am.
A2 to A7.
Yes, I have filed a miscase IA for bail, my lord.
What is that number?
That is 396 of 2023.
That is in the list.
Yes, my lord.
No, where is that application has been filed for all the petitioners?
Yes. Thereafter, he has sent a prisoner petition.
So if you have appeared subsequently, why don't you file a separate one? Now he is not the counsel. That application, interim application.
I can also file a separate.
Right, that
could be touched.
Better let it be listed anytime you want. When you will file that interim application?
By tomorrow.
So file it, then it will be listed.
Let it come on Friday, my lord.
Okay, let me. It is stated by Mr. Niranjan Panda, Land Counsel, that is appearing for appellant number 1, Damborudhar Bhatra alias Damboru, and has filed the Peenama, which may be accepted. The Mr. Jyotirmoy Sahu Land Council submits that he is appearing for appellant number 227. Stop. The interim application, that is IN number 396 of 2023, has been filed for all the appellants. Mr. Panda submits that he intends to file a separate interim application for bail for appellant number 1, Damborudhara Bhatra alias Damboru, during course of this week. Put up this matter with the IA, if any, filed by the appellant number 1 next week. Okay? Yeah.
Next Monday, well.
Next week, man, next Monday.
Oblige.
Item number 28.
Here, my lord, the present appellant has preferred a interim application, and my lord has kind enough to grant him interim bail by order dated 21/5/2024. Madam, I see the third page of the internal page of the order, my lord. Mid part. Considering submission made by the Land Council for the suggestions, the medical documents attached thereto, and the report furnished by the Land Council for the state, we are inclined to release the petition on interim bail for a period of 1 month from the date of release, and the petitioner shall surrender before the Land Trial Court immediately on expiry of the period of 2 months.
Oh, see you 1 gotere 2 months
and in the meantime also, and in the meantime also, because of the fact that this order was ambiguity, I have directed him to surrender. He has also surrendered on 27th.
So if you have surrendered, then what can be done? That order has already been acted upon, and you have been granted bail, and you have already surrendered.
So clarify that.
No, you can file another application. There is no problem. IA number swan. So this is an application for modification of the order. The Mr. Chan Land Council for the petitioner submits that he intends to withdraw this interim application to file another interim application for interim bail. In view of such submission, IA stands disposed of.
Item number 29.
Yes.
May I please your lordship, my lord prefer 2 weeks later, that is 22nd July.
Okay. What is your good name, madam?
Anjana Misra.
A. Misra.
Yes, sir.
Land Council appearing for appearing for the appellant 6 for an adjournment till 22nd July 2024. Put up this matter on in the week commencing from such and such date. Hello?
Item number 30.
My lord. Item 30, my lord. Petitioner challenge, appellant challenge judgment dated 17/12/2021, my lord.
Just a minute. So what is the date of custody?
My lord, date of custody 8/3/2015, my lord.
8/3/2015. And you have been convicted under section
302 34 IPC and so 304B 34
so
498A.
This JCRLA has been filed by Ramachandra Parida only.
Yes, my lord.
Who is the other one who faced trial along with you?
My lord.
Ranjan Parida and Rajani Parida.
Rajani Parida.
Have they filed a separate JCRLA, or have you got any instruction about their appeal numbers?
No, my lord. I have no instruction.
They are not file any JCRL.
No. This is JCRL for all the three. It is for all the three. You are not aware. So
I am moved for bail, my lord. Only Ramchandra Parida, my lord.
IN number 10 you have filed only for Ramachandra Parida.
Yes, my lord. He is now, my lord, 75 years old.
Just a minute.
You have been engaged by legal services by the court.
No, my lord.
You have got the private ones. You have filed
NGO.
Vinama.
Through NGO, my lord. One NGO.
NGO?
One NGO also engage me.
No. Mr. Counsel, what is your good name?
Sapan Kumar Pal, my lord.
This court engaged by order dated 15/2/2022.
Yes, my lord.
Engaged Mr. Subodh Kumar Mahanti.
Yes, my lord.
As the counsel on behalf of the Odisha High Court Legal Services Committee.
Yes.
To conduct the appeal.
Yes.
Then as it appears, some prisoner's petition was received for engagement of Mr. Sushant Kumar Das and his associates.
Yes,
and accordingly they have also filed the Vinama. ତେଣୁ ସେଥିପାଇଁ direction ହେଲା ଯେ the name of the earlier engaged counsel shall not be reflected. So Vinama has been filed by Sushant Kumar Das and his associates. So how you came into picture?
Sushant Kumar Das and associate. I am his
So
associate.
you are part.
Yes.
Okay. Then it's all right. So all right. So now you have filed power for all the three.
Did you file power?
Power for all the three, or you have filed only for this appellant number 1? This you jaha kହୁchandi
Ramchandra Parida.
Ramchandra Parida.
Yes.
Taଙ୍କ Vinama ta dekhile. Sushant Kumar Das, Sapan Kumar Pal. It is only for Ramchandra Parida.
Yes.
This अन्य दीटा रही गले.
I have also filed only bail for only Ramachandra Parida. He is 75 years old.
No, it's all right. But now who is to represent the other two? Because all the three filed one prisoner's petition.
Yes.
On the basis of which one advocate was engaged. We were under impression that perhaps you have filed the Vinama for all the three. That is why we disengage the other counsel. But you have filed the Vinama only for one. So there is no problem. We can also engage you for conducting the case of the other two.
Yes, madam.
Conclusion. Can we engage question after the Procedural? Sushantର ବର୍ତ୍ତମାନ disengage ହେଇଗଲାଣି court order ବେଳେ ସେ କହିବା କଥା ଯେ ମତେ ଯେ ଆମେ 3 ଜଣଙ୍କ ପାଇଁ କହୁଛି ତାଙ୍କ ପାଇଁ ସେ 2 ଜଣଙ୍କ ପାଇଁ ସେ ରହିଥାନ୍ତେ ମାନେ ସେ ଆଗରୁ ଯୋଉ କାଉନସିଲ ଏନଗେଜ ହେଇଥିଲେ ବର୍ତ୍ତମାନ ଅର୍ଡରଟା ହେଇଗଲା the name of the earlier engaged counsel Subodh Kumar Madi shall not be reflected in the court. We have engaged Mr. Subodh Pantana. We had engaged one Subodh Kumar. That is the order dated 15/2/24. After that, he has filed the Vinama. So Vinama what for one? It can be done in one way. The other two appellants who have also case they are related to each other. These three appellants.
Yes, my lord.
Then they may agree also. अच्छा काली गोटे काम करंतु आपण से जो अन्य 2 जण जो प्रिजनर अछंती को थाना एठी अछंती माने सब
चौदार अछि
हां सर्कल जेल 14 रे अछंती तांको ସେମାନେ ହେଲେ ରଞ୍ଜନ ପରିଡ଼ା ନାଁ ଗୁଡା ଟିପନ୍ତୁ।
ରଞ୍ଜନ ପରିଡ଼ା, ରଜନୀ ପରିଡ଼ା, my lord.
ରଞ୍ଜନ ପରିଡ଼ା, ରଜନୀ ପରିଡ଼ା
My lord.
କାଲି କହିଦିଅନ୍ତୁ 10:30 ରେ ଭର୍ଚୁଆଲ ମୋଡ୍ ରେ ତାଙ୍କର ଆପିୟରାନ୍ସ କରେଇବେ
ଆଜ୍ଞା।
ହେଲା। ଆପଣ ରହିବେ 10:30।
ଆଜ୍ଞା ମାଲିକ।
ସେ ଯଦି କହିଦେବେ ହଁ ମାନେ ଆମର ସେଇ କାଉନସିଲ କରିବେ ବୋଲି ଆଉ କିଛି ଅସୁବିଧା ନାହିଁ ହେଲା। So we are not passing any order but you just made.
My lord.
କାଲି ଡାକିବେ 10:30।
Item 31.
Please, my lord. My lord, here the appeal is directed against the order passed by the London Session Judge both was also pleased to convict me under section 302 IPC. My lord, so far the fact of the case is concerned that there was an unknown affair, a dead body was also recovered and the affair was unknown, and they are also doubting that in the previous night there was a quarrel between the deceased with the petition.
Just a minute. What is the date of custody?
Custody is at the 20th 10 2016. 2016.
So you have never been released on bail during trial. And you have been found guilty under 302.
Only 302.
And sentenced to life imprisonment.
Life.
Right?
Yes.
So what is the name of the deceased?
My lord, that is
Sudhir
Kahara, Sudhir Kahara.
Sudhir Kahar. And date of occurrence?
Date of occurrence?
16th night to 16/10/2016.
16/10/2016.
Yes.
Whether it's a case based on circumstantial.
Last scene
and recovery of the
Just a minute. Circumstantial evidence. Last scene. Out of
recovery of weapon 27.
Recovery of weapon. So this appellant and the deceased, are they related to each
No,
other?
no.
Friends.
No, they are not related.
Okay. So who has stated about the last scene?
PW 5678.
PW 5678. And recovery of weapon. What is that weapon?
X.
X. It is deposed to by
PW 14. IO.
PW 14 is the IO.
No. PW for the witness to that.
And the IO. Right. So where they were last seen according to PW 5? Punch.
In a melody party, there was a melody.
Just a minute. Come to PW 5. Please place it. PW 5.
I know the accused S.K.Sahoo, but I do not know the other accused person in this case. Accused S.K.Sahoo, Kanishta Monohira, and Padma Behera are present in the dock. I know the informant Swapna Kahara, who is my co-villager and is also related to me as sister-in-law, wife of the brother, as per our village courtesy. I also know the deceased Sudhir Kahara. The occurrence took place a little over than 9 months back at the Bhagipoda. That day, I along with the Prakash had come to the Bhagipoda to watch a melody program which was going on at Bhagipoda at that time. During the said melody program, we had gone to the shop and placed orders for the taking the chowmin there. At that time, we found that the accused Jaswanta and the deceased Sudhir Kaur were quarreling with each other near the chowmin shop. We intervened and separated both of them. At that time, one Mrutyunjaya and Narottam were also present at the spot, and we all together, including Mrutyunjaya and Narottam, had pacified the accused Jaswanta and deceased Sudhir, and then separated them. The time was also that around 10 p.m. in the night. Thereafter, we all, myself, Prakash, Sudhir, Jaswanta, Mrutyunjay and Narottam went to the Jatra field as the melody program started. About 1.5 hours after, we saw both Jaswanta and Sudhir going away together from the Jatra field. It was about 12 o'clock in the night when we found both of them leaving the Jatra field together. Then on the next day morning, I heard Sudhir was no more. I came to the spot at a Bhagipada and found the dead body of the Sudhir lying in a field. Sudhir had a hacked injury in his head, and further his private part was also cut, and the same was also kept in his chest. In cross-examination, our village Sama Puja and the distance between the Bhagipada is about the 8 kilometers. On the relevant night, we had come to the Bhagipada riding our cycle. The melody program was held on the middle of the Bhagipada village on that relevant night. The Chowmin shop was also located near the place where the melody program was going on, and further the viewers in the said melody program were also present quite near the Chowmin shop. I cannot say as to whose houses are located near the house Chowmin shop at the village Bhagipada. I had noticed the accused Jaswanta and the deceased Sudhir quarreling and fighting with each other near the aforesaid Chowmin shop. There is a brewery at the little distance from the aforesaid Chowmin shop, and the said brewery cum liquor shop was open at the relevant time, and I had noticed many people coming from the side of the said brewery cum liquor shop towards the Jatra field during that time. People were also passing through the aforesaid Chowmin shop when the accused Jaswanta and the deceased Sudhir were also fighting with each other near the said Chowmin shop. I had not seen as to whether the Jaswanta and the Sudhir had sustained any injury on their person on account of their fighting with each other at the relevant time. The village of Jaswanta is situated at a distance of about 10 to 11 kilometers from the Bhagipada towards the side of both. I had seen Jaswanta for about 3 to 4 times.
So, Mr. Tripathi, there was some dispute, of course, there, but it was specified as it appears. And then they were seen together. So, on the next day, the dead body was found. Yes. So, at that point of time, there was no weapon in the hands of Swancho. So, what is the place where the deceased was found?
Appellant was the forest guard.
Oh, yes, forest guard, and the weapon was also with them in that office. And that has recovered
from that office. Recovered.
Akuda?
That weapon was seized from that forest
office.
bit of
Office. Bit of
Yes, they came there and it was seized. PW 14.
2016 ରହିଲାଣି ଆଉ କିଛି ଅଛି criminal antecedent?
no.
But I have
No.
accepted.
A young boy of 19 years old.
Just asking him.
Sir.
Is a government servant?
No, no, he was temporarily got appointed as temporary watchman.
Watchman.
Yes.
All right, you obtain the instruction about the criminal antecedent. The land counsel for the IN number so and so. This is an application for bail. The land counsel for the state seeks some time to obtain instruction about the criminal antecedent, if any, against the petitioner. So also the conduct of the petitioner in the jail. Put up this matter and we commencing from 15th July 2024. He stated to be in judicial custody since 2010-2016. Custody certificate may also be produced. So it is to come on 15th July 2024. So rest of the matter after lunch we'll take.
I'd like to make a mention, my lord. Item 56 of today's list, my lord. We have filed a IA in that matter, my lord. It is listed under the heading of hearing, my lord. I pray to be listed it maybe listed it tomorrow with the heading orders, my lord.
What you are doing in the first hour?
Sorry, my
So
lord.
you can come at any time, and without knowing that what the court is dealing with, you can mention at any point of time.
Forgive me,
That
my
is
lord.
what your senior has asked. Which matter you are mentioning?
Item 56.
What do you want?
Maybe listed up tomorrow, my lord, with the heading
Why
orders.
it will be listed tomorrow? It is there in the weekly list. As per the previous order passed, it must have come under the heading of hearing list. Why it will be taken up for orders?
We have filed a IA in that matter, my lord.
In many hearing matters, IA are pending, and in spite of that, since perhaps the court was not inclined to grant bail or see that it is a old matter, so it can be hard. It has come to get ready for hearing.
Mal.
Yes.
Item number 32. Item 33.
Your Lordship, pray for time after next week.
No. You have been engaged. This is JCRLA. So, how you are engaged? As a prisoner's petition has been received. Requested to contact Mr. Vishwajit Tripathi in his phone number. It was informed that he has agreed to file VNAMA. So, now you have been engaged and you have filed the VNAMA. But the stamp reporter has pointed out that there is delay of 66 days in preferring this jail criminal appeal. So you are to file an interim application for condonation of delay. For that, you took adjournment. Have you filed that interim application?
No. Next week.
You want it next week? Grant counsel for the you are to file that interim application then during course of this week, or you will file it by next week. It will come a week after. কেবে file করিবে?
এই উইকের ভিতরে করে দিও।
এই উইকে করিবে। The learned counsel for the petitioner submits that during course of this week will file the interim application for condonation of delay. Matter will be listed on 8th of July 2024 if any such interim application is filed during course of this week. Yes, next.
Yes.
Item 34.
Item 34, my lords. I have not been supplied with the paper book, my lords. Let it come after 2 weeks. In the meantime, I will collect the paper book, my lords.
No, uh, it is a 2023 JCRLA.
Yes, my lord.
So why it will be given preference over other criminal appeals and jail criminal appeals, old criminal appeals which are pending? You have filed a bail application, yes, it can be adjudicated. But why this case be given preference over other? So many appeals have been pending. Hundreds and hundreds of appeals are pending. Why your appeal of 2023 will be hard on merit? What is so special in it?
No, my lord, nothing like that.
Then you move the bail application, you move. That's a different matter.
The petitioner.
You are ready in the bail application?
Yes, ma'am. But actually, I need the
Just a
paperwork.
minute. Wait. What is your good name?
Abhishek Mohanty, my lord.
Abhishek Mohanty. You have also filed your Vinama.
Yes, my lord.
The court engaged you.
Yes, ma'am.
As the Lanen amicus curiae.
Yes,
right?
Yes.
So when you are filing Vinama, why are you indicating the names of other counsel?
By mistake, my lord.
It should not have been done.
Yes, ma'am.
Okay. Because the court had only engaged you, not your associates. If it is a private brief, matter is different. So what is the conviction and what is the sentence?
Conviction under 302, my lord, for life, my lord. The same is at page.
And you are in custody since when?
26/1/2016, my lord. More than 8 years.
26/1/2018.
16.
16.
Yes, my lord.
What is the name of the deceased?
Punna Das.
So you assaulted the deceased with a cautery on the neck.
Yes, my lord. As per the allegation, my lord.
And the doctor is PW?
Doctor is PW11.
PW11. Who are the eyewitnesses to the occurrence?
PW1, PW10, PW13 and 14.
Wife will be definite.
Yes, ma'am.
Wife is one of
PW1 is the
PW1.
one.
Chop wound of size so and so, wound deep, horizontally so and so. So it is a Cuttack case, Tulasipur.
Yes.
So what about the criminal antecedent? Take instruction. Take instruction. Look on. IA number 170 of 2023. This is an application for bail. The learned counsel for the state seeks some time to obtain instruction regarding criminal antecedent, if any, against the petitioner. So also produce the custody certificate of the petitioner, who is stated to be in judicial custody since 26/1/2016. Put of this matter will be commencing from 15th of July 2024. IA number 171 of 2023. Stay of realization of fine allowed.
Which jail? O jail.
15th
jail.
କହୁଛନ୍ତି 14 ପରା
ଚୌଦ୍ୱାର
ଦେଖି ଭି ନାମଟା ଦେଖି JCRL ଚୌଦ୍ୱାର वकालत नाम 14 जेल ଅଛି. You will get the instruction. Published.
Item 35.
Lordship, this case may be taken up to week, Your Lordship.
Yeah. So it will be taken up on 15th, or you want more time?
15th.
15th.
Let us have the deposition copy.
Deposition copy. We collect the from the pen drivers. The trial court record is here. What is your good name?
S. Bhuyan.
You have got no power in this case.
No, Your Lordship.
You are mentioning on behalf of Mr.
A.K. Panda, Your Lordship.
A.K. S. Bhuyan, learned counsel appearing for Advocate Alok Kumar Panda, 6 for an adjournment. Put of this matter will be commencing from 15th July 2024.
Item 36.
36, my lord, spring for matter taken up next week, my lords.
Next week?
8, lords.
Mr. Mahanti, learned counsel appearing for the appellant, 6 for an adjournment till next week. Put of this matter on 8/7/2024.
Grateful, lords.
Item 37.
There is a delay in filing the appeal. The delay is around 30 days, Your Lord.
This is CRLA for offenses?
Offense under section 302, Your Lordship. 302, 120B, 452.
302, 307, and 452.
Okay.
Page 30.
What is the delay period?
30 days.
Delay is around 30 days, Your Lordship.
31 days. 31 days. All right. IA number 1428 of 2024. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 31 days in filing this appeal. After hearing the learned counsel for the respective parties going through the averments taken in the interim application. And since it's a case where the petitioner has been sentenced to imprisonment for life, we are inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Admit call for the trial court record. Interim applications. File the bail fine. Bail and sterilization fine.
Yes.
We consider after receipt of the trial court record.
Pass over item number 6. Item 13.
13, 13 or 14? Yes, Mr. Japur. Mic use करंदो.
The appellant has been convicted under
Single appellant.
Single appellant, and prosecution case is that the deceased who is
Yeah, just a minute. Kunjal Bhumis. What is the custody date?
custody date malat on the 22nd 11. Malat it appears in the
trial court record bar karo.
11/6/22.
Final form of 20 forwarded to court on upon Kunjal तो 23/11/2016
ଆଜ୍ଞା
2016 ଯାଇନାହାନ୍ତି ଜମା
ନାଇଁ after conviction is not first bail application.
produced in custody. Okay. So, and in this court also you have never been released on bail?
No, my lord. This is a first bail application.
All right. What is the name of the deceased?
The deceased name is Saraswati, who happens to be the sister.
Saraswati.
Is the sister-in-law of the appellant, Bhaujo.
Bhaujo.
Aye.
Sister-in-law.
And the genesis of the case in FIR is lodged by informant, who's the PW1, who is the Malat neighbor, and the who stated that after the occurrence he went to this is a post-occurrence witness, and the trial court has heavily relied upon the evidence of PW10, who happens to be the sister of the deceased.
Eyewitnesses
an
are there.
eyewitness to the
Yes.
occurrence.
PW10. PW10.
Yes, my lord. So, my lord, trial court has heavily relied upon that evidence, my lord. PW10.
And who is the doctor who conducted PM?
PW7. PW7.
Please come to the evidence of PW10.
My lord. Yes. May I read, my lord?
Yes.
I know the informant. I know the accused standing in the dock, whose name is my sister. She died about 1 year back. On the date of on the occurrence day at about 10 a.m., I had been to the house of the deceased to collect gourd and tomato. When I was talking with Saraswati at her house, the accused ate the tiffin prepared by Saraswati, which was kept at the outside of the house. We both came out and asked the accused as to why he ate the tiffin meant for children, but the accused did not answer. While Saraswati was returning after cleaning the tiffin, suddenly the accused came behind and pushed her from backside, for which she fell down on the ground. Accused picked up a log of char and inflicted 4 to 5 blows on her head. When I intervened to save my sister, the accused twisted my hand. I shouted for help, but nobody came out. In fear, I ran to my basti and informed my brother, Kabula Bhumi, not examined, that the accused has killed Saraswati. I have been examined by the police in connection with this case.
Okay, now come to the evidence of the doctor. PW7.
My lord. In doctor's evidence,
lacerated wound on the maxillary bone.
He observed as follows: the presence of an antemetum lacerated wound of size so and so, maxillary bone deep present over right side of the cheek of the right face, multiple fracture of right orbital bone of right eyes, an antemetum lacerated wound of size so and so, bone dip present before the lower lip over the chin of the face. All the scalp hair stained with dried blood, presence of an antemortem lacerated wound with open fracture of skull bone of size of 10 inch to 8 inch, a brain matter dip present over the left side of the scalp over left parieto-temporal occipital area of scalp. Right side of scalp was intact. Skull bone of the right side are intact. Left side skull bone multiple with open fracture through which the brain matter are whipped up. The membranes crushed, pale, and the brain matter of the left side of the brain cavity are crushed, pale at the fracture area of the brain cavity. The right side brain matter are intact and pale. Stomach intact, pale, lumen contents which liquid fluid of 50 ml with strong alcohol-like smelling desi alcohol.
So it appears you have given repeated blows.
Yes, there is a
all the injuries were on almost on the head, confined to the head, maxillary bone, fracture, multiple fracture, right orbital over the right eye, then another one wound in the lower lip. So it is brain matter has come
there
out.
is also internal damage is also there. So he has as it appears from the injury report, he has assaulted on the face and head, that is vital part, and cause of death is due to coma due to head injury.
That is mentioned in paragraph number 3.
The cause of death is coma due to head injury. Third line.
She had kept food for her children, and you are the person who ate it. And when she just asked you, why have you take eaten away the food which I have prepared for my children? You did this and assaulted on the vital part of the body, repeated blows on a lady. What is your submission?
My lord, the cross-examination, only I will
And you must be staying in that house also.
Is
your sister in one compound.
ଇଏ ଆଉ ଗୋଟେ ଘରେ ତା ମା ସହିତ ରହୁছে ଚାରି ଭାଇ ଆଉ ଇଏ ଗୋଟିଏ ଭାଇ ମା ସହିତ ସେ is unmarried.
Once you are released on bail,
they is saying that they have all the cordial relationship between all of them. That's better that there is no strained relationship with anyone. All have cordial relationship.
ମାନେ ସାକ୍ଷୀ ଦେଇଛନ୍ତି ତାଙ୍କର ଏଇ ଯୋଉ କଣ ତା ନା PW10
ଆଜ୍ଞା
ସିଏ
she has also stated that deceased has a cordial relationship with the accused. Accused has a cordial and and so far the blow is concerned at the assault is possible at the paragraph 6 of his cross-examination.
Even after you add the
she stated to have assaulted 4 to 5 blows
at her head.
ହେଲା ଗୋଟେ ବ୍ଲୋ ହେଲା ଅଲଗା କଥା
ସେ ଚାରିଟା blow, that is first time
ଦେବେ ଆପଣ
that part is for the first time she has stated in the court in paragraph 6, my lord.
No, medical evidence is there.
That is I'm not disputing the medical evidence, my lord. And IO
out of being enraged on the questions, if a blow is there, yes, we can understand.
And IO also has admitted in para 10, para 14 regarding the assault part is concerned, my lord, in para 6 that has been confronted to her, and para to PW10. It is not a fact that I have not stated before the police that accused picked up a char name of a tree and inflicted 4 to 5 blows on the head of the deceased, and that when I shouted for help, nobody came out, and in fear I ran to my basti, inform my brother Kabulal Bhumij that accused has killed Saraswati. That has been confronted, and accused
you have not completed even 8 years. You are
yes,
7 years and
furthermore, my lord, PW 10 has also admitted that the deceased has a good relationship. There is no, my lord, all were
That is now the results in place.
Are the learned counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 23/11/2016, and the petitioner is the brother-in-law of the deceased, and on account of grave and sudden provocation, he assaulted the deceased, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, placed the evidence of P.W. Tain, who is the sister of the deceased Saraswati, and she has stated that when the deceased confronted the appellant as to why he ate the tiffin prepared by her, which was meant for her children, the appellant suddenly picked off a log of char, CHAR, and inflicted 4 to 5 blows on her head. The learned counsel for the state also placed the evidence of Dr. PW7, who conducted post-mortem examination over the dead body and noticed one lacerated wound on the maxillary bone, multiple fracture on the right orbital bone of right eye, lacerated wound on the lower leaf, and he found that the injuries noticed on the head of the deceased were sufficient in ordinary course of nature to cause death, and the cause of death was on account of coma due to head injury. The wooden log, which was seized by the police, was also examined by the doctor, and he opined that all the injuries on the dead body would be possible by such weapon. Considering the submission made by the land council for the respective parties, the manner in which the occurrence has taken place, the number of blows the petitioner has dealt to the deceased on the vital part of the body, we are not inclined to release the petitioner on bail. Rejected. Stay realization of fine.
Item number 32.
May I please, my lord? Yes, the appellant were convicted under section 458, 394, 376D, and 506 and 34 of IPC.
Young Reef case.
Yes, my lord. 4 accused are there. I am for one of the appellant, Dilip Das.
What happened to the other co-accused persons?
They are another criminal appeal.
What happened? Have they filed any
Yes, madam.
application for bail?
Yes, madam.
What is the result of those bail applications?
So the another advocates have engaged. I don't know. The pending, my lord. Their bail application is pending.
Okay.
Now, in respect to
Other three accused.
There are
No. Here it is Dilip Das.
I am for one of the accused.
You are for
Dilip Das.
Dilip Das. Earlier it was rejected.
Earlier interim bail was
Interim bail was also rejected.
reading a mother death.
No, the other co-accused persons are Sanjay Das, Gadadhar Das, and Jaga Das.
Jaga Das.
They were also found we have to take up item number 2, na?
Item number 2.
So that jail, that arrangement has been made. Connect to that jail. In which jail they are now?
Noyad.
Kindly unmute, sir.
पता ही नथले कि ओपन करना से रिक्वेस्ट करा फंसा उठा ये टाइप मारी किन तद्राणी बट आगे नहीं एसोसिएट
Kindly unmute.
निरंजन मलिक ये वकील बाबू की अच्छी
ନାଇଁ ଅଛନ୍ତି କି ନାଇଁ ପାଖରେ
हाँ कही नथिले कि
ଆଜି ଆସିଥିଲେ
केमती कौन बारंबार गोटे कथा कहूँ केमती हाँ हाँ No, it's all right. If it is Berhampur, then the prestigious Berhampur should have been told to arrange, send one of the lawyers. Huh? ଆଉ ଆପଣଙ୍କର କାଉନସିଲ ଆର୍ଗୁମେଣ୍ଟ କରିବେ ତ ବ୍ୟବସ୍ଥା କରାଯାଉଛି ଜଣେ ସରକାରୀ ଓକିଲ ଆପଣଙ୍କ ପାଖରେ ରହିବେ ଏବଂ ଯୋଉ ଶୁଣାଣି ଯାହା ହଉଛି ସେ କଣ ଆପଣଙ୍କର ଯୁକ୍ତି ଉପସ୍ଥାପନା କରୁଛନ୍ତି ଆପଣଙ୍କର ଆଡଭୋକେଟ ଆଉ ସରକାରୀ ଓକିଲ ସେ ସବୁ ବିଷୟରେ ଆପଣଙ୍କୁ ବୁଝେଇ ଦେବେ ଏବଂ ଆପଣ ଯଦି ଆପଣଙ୍କର ଓକିଲକୁ କିଛି କହିବାକୁ ମଧ୍ୟ ଚାହାନ୍ତି ସେ ବିଷୟରେ ମଧ୍ୟ ଆପଣ କହିପାରିବେ କିଛି ଅସୁବିଧା ନାହିଁ ହେଲା ତ ବର୍ତ୍ତମାନ ଶୁଣ କିଏ ଅଛନ୍ତି ପୋଲିସ ବାବୁ କିଏ ଅଛନ୍ତି ହଁ ସେ ଆମେ ଯାହା କହୁଛୁ ଠିକ ଭାବରେ ଶୁଣା ଯାଉଛି ତ Standing instruction. हाँ से कैमरा को ये कर दियंतु आपण शुणंतु ए विषय आमे जहाँ कहूचु शुणा जाउची तो हाँ एडवोकेट जहाँ आर्गुमेंट करिवे आपण से विषय शुणंतु एवं कालीठू यदि आज न ही पारला तो कालीठू एडवोकेट जने आसी आपण पाखे रहिबे हला ओके सो कैमरा को ये कर दियंतु डायरेक्शन दियंतु कोन हाँ ठीक है यस मिस्टर पंडा
May I please?
It's a case under section
302 IPC, my lord. Before
There are other offences also, but conviction is only under 302.
no, my lord, other offenses.
Other offences.
So
302, 307, and
why don't
also
you go come to that operative portion
My
of
lord.
the judgment
My lord.
where the you have been
Conviction,
found guilty under and what are the sentence imposed?
my
Yes.
lord.
Okay, maybe that is at page 176.
76, my lord. Convict Niranjan Malik is sentenced to death for committing the offence of murder, punishable under section 302 IPC, and to pay fine of rupees 50,000 in default RI for period of 1 year. He be hanged by his neck till his death, rigorous imprisoned till end of life, and to pay fine of rupees 50,000 in default RI for period of 1 year for offence punishable under section 307 IPC. Rigorous imprisoned for a period of 3 years and to pay fine of rupees 5,000 in default RI for
50,000 is there?
I may pardon?
50,000 is there?
Yes, my lord.
Ah.
50,000 column 2.
Ah.
Rigorous imprisoned till end of life and to pay fine of rupees 50,000 in default RI for period of 1 year for offence punishable under section 307 IPC.
Right.
Rigorous imprisoned for a period of 3 years and to pay fine of rupees 5,000 in default RI for period of 6 months for offence punishable under section 325 IPC. Rigorous imprisoned for a period of 10 years and to pay fine of rupees 5,000 in default RI for period of 6 months for offence punishable under section 326 IPC, and rigorous imprisoned for a period of 3 years and to pay fine of rupees 5,000 in default RI for period of 6 months for offence punishable under section 458 of IPC. Sentences are to run concurrently. Entitlement of under section 420 CRPC is subject to modification of death sentence and invocation of section 433/433 CRPC by the appropriate. Death sentence shall take its effect upon receipt of the result of the death reference to made to the Honorable High Court. Entire proceeding is submitted to the Honorable Court forthwith. Compensation of victims of the crime. In the case at hand, two helpless unarmed persons, Badani Pradhan and Lochan Sethi, succumbed to the injuries due to the hostile horrendous of the accused. Besides, injured persons Sulochana Pradhan and Amuli Barik received fatal injuries on their body. One Damodar Sahu all lost the distal phalanx of his left little finger. Considering the impact of the alleged crime upon the victims and their family, compensation worth of rupees 5 lakhs and rupees 2 lakhs are awarded to the legal heirs of the deceased persons, Badan Pradhan and Lochan Sethi respectively. The Secretary DLC Nayagad is requested to take necessary steps for payment of the compensation to the legal heirs of the deceased persons. The Secretary DLC Nayagad is further requested to consider the case of other injured persons, Sulochana Pradhan, Amuli Barik, and Damodar Sahu, so as to award compensation to them for being suffered from injuries due to the alleged crime.
Okay.
Before parting with the case, I have prepared a short note regarding.
Just a minute, as you have placed that. So in this case, there are two deceased.
Yes, madam.
One is Badani Pradhan, the other is Lochon Sethi.
Madam.
Then there are two injured persons also.
Madam.
One is Sulochana Pradhan.
My lord.
She is PW.
13.
And the other is Amuli Barik. PW.
5.
5. So these are all the
Another is the PW 15 is also
Damodar Sahu. Damodar Sahu, PW 15. Damodar Sahu lost the digital file. Okay. All right. No, we'll go to your note. Place the past information report.
My lord.
Then.
Page 21, my lord.
Yes, please. It's in Nali pencil. Please.
माननीय श्रीयुत आदर्श थाना भारप्राप्त अधिकारी ओडगां नयागढ़ महाशय मोर नाम मनोज सेठी बयस 20 वर्ष पिता लोचन
मनोज सेठी PW 2
my lord. पिता लोचन सेठी साकनी जामुसाई पोस्ट रंगणी पाटणा थाना ओडगां जिला नयागढ़ आपण को जणाउछि कि मोर बापा लोचन सेठी बयस 53 वर्ष पिता तीना सेठी प्राय 3 वर्ष है ओडगां परिवा मार्केट रे रात्र जगुआली भावे कार्य करी आसुथिले सबुदिन भली गत 16/1/19 रिख रात्र प्राय 11 घंटिका समय मोर बापा आम घर ड्यूटी करिया पई ओडगां परिया मार्केट आसिले एवं मोर बापा ड्यूटी करुवा बेले आज ता 17/1/2019 रिख रात्र प्राय 2 घंटा समय बस स्टाण्ड ठारे निरंजन मलिक ओरफ नंडा पिता चंद्रमणि मलिक साकना पूर्णा कुशुड़ी पिता साकेरी थाना ओडगां जिला नयागढ़ गोटे काठ फाड़िया मोर बापा को जीवन में मारिदेवा उद्देश्य मोर मुंड को लक्ष्य करी शक्त प्रहार बाड़े मो बापा मुंड गभीर क्षत हो प्रचुर रक्त साबुची मोर बापा को चिकित्सा
give a pause for a moment. The date of occurrence, just date of occurrence when 16-17 16-17 intervening night January maso 2019 place of occurrence hochi ko bus stand seta
ओडगां परिया मार्केट
asile bapa duty kortla bola aji swanso bus stand thare pura kochi राति 2टा बेले बस स्टाण्ड ठारे निरंजन पंडा
निरंजन
काठ फाड़िया मोर बापा को जीवन में मारदेव उद्देश्य मुंडू लक्ष्य करी बस स्टाण्ड घटना कहूँ प्लेस ऑफ ऑकरेंस
that is जो occurrence place my lord bus stand जोड़ा कहउछन that is back side of the bus stand near the Ganesh Bazaar
गणेश बाजार
near the Ganesh Bazaar
अच्छा अच्छा पढ़ंतु
गोटे काठ फाड़िया मोर बापा को जीवन में मारिदेवा उद्देश्य मुंड को लक्ष्य करी शक्त प्रहार बाड़े मो बापा मुंड गभीर क्षत हो प्रचुर रक्त साबुची मोर बापा को चिकित्सा निमते ओडगां डाक्तरखाना को अणागला डाक्तरखाना को नया डाक्तरखाना रेफर कले डाक्तर बाबू नयागढ़ डाक्तरखाना को रेफर कले नयागढ़ डाक्तरखाना रे चिकित्साधीन अवस्था बापा मृत्यु घटिला उक्त मुदला आज रात्र 3टा बेले ओडगां सिनेमा हल साईर बदनी प्रधान अनादर डिसीज्ड स्वामी वीर प्रधान घरे पशि झील सुलोचना प्रधान को मरणात्मक आक्रमण करिछि जहा द्वारा बदनी प्रधान घटनास्थल मृत्यु होइछि सुलोचना प्रधान जीवन संकटापूर्ण अछि से वर्तमान भुवनेश्वर चिकित्सित हेउछन्ति उक्त मुदला निरंजन मलिक ओडगांर श्रीमती अमूली बारी को मध्य मरणात्मक आक्रमण करिछि से एबे भुवनेश्वर चिकित्सा हेउछन्ति ओडगांर दामोदर साहू और अन्य माने मध्य उक्त मुदलांक आक्रमणर शिकार होइछन्ति उक्त घटना आज रात्रि 2टा ରୁ 4ଟା ଭିତରେ ओडगांरे घटी अछि ଏଣୁ ଘଟଣାର ବିହିତ ତଦନ୍ତ ନିମନ୍ତେ ପ୍ରାର୍ଥନା କରୁଅଛି।
No, this father of or the informant is anyway related to this the Badani Pradhan.
No, madam.
No, madam.
Then why it was tried in one trial?
It was one day occurrence.
No, one day.
That's true. One day occurrence.
Sentence ta ani thibe na.
Exactly.
The multiple murder has been committed. Maybe we do not know. But as it appears, one incident
That should be different. Because occurrence place is different.
Place of occurrence local. हाँ गोटे transaction
हाँ,
रे आपनकर जदि हेई थांदा
different.
आपण गोटे accused एठी ये करछि तापरे आउ कि सम परे आउ गोटे जगह रे अन्य गोटे कहा संगे रे करछि ता संगे आर किछि
लिंक नाही
लिंक नाही
कि मोटिव भी सेम किछि नाही connection
judgment देखिए
again
how then charge is one if it is distinct and different how could the charge be there charge केमती हला गोटे charge is की अर्थन
charge 24
charge ता पढिले
24 टक्स
charge ता केबे
charge 24
दीटा charge
गोटे दीटा charge है और second charge है additional charge हला सी जो 7 गोटे छाडी जेतले तीनटा इन्यूट द सेकंड आउट एडिशनल करले ड्यूरिंग द ट्रायल
नाही ए जो मर्डर पई आपण दीटा डिसीज पई गोटे चार्ज करछन
but charge is in is
24 my lord.
Wait, let us see that charge.
One charge. First, that you on 17th day of January 2019 at about 2 a.m. at Odonga Vegetable Market committed murder by intentionally causing death of Lochan Sethi, and on the said date at 3 a.m. committed murder by intentionally causing death of Bodani Pradhan after entering into her house, that you thereby committed an offence punishable under section 302 IPC and within the cognizance of this court. That you on the next matter. That you on the same day and place in between 2 to 4 a.m. assaulted Sulochana Pradhan and Amuli Barik with such intention and under such circumstances that you thereby caused hurt to Sulochana Pradhan.
So
and
it means suppose somebody commits theft at one place, commits murder at another place. Third offense so जेतिको से दिनोटारे करथिबो सब पई गोटे ट्रायल कर देगिन ताऊ तो it's a
and also the so far as the 307 part is concerned, my lord, that is also different place of occurrence,
in
different
respect of different
high places occurs different.
Then Mr. Das, why didn't you point out earlier? You should have pointed it out. It's your matter.
Yes.
Before going for the hearing, this could have
My
been taken as preliminary issue.
Yes,
You could have gone for the charge.
Right.
If the charge is not proper, where is the question of going to the merit of the case?
My lord is 100%. Currently, punishment conviction has been made.
So
Also.
that is because of this. That
Yes,
is why exactly. Suppose
yes, ma'am.
it would have been distinctly tried.
Different.
He might not have been sentenced to death.
Yes, ma'am.
सब केस रे हुए तो से लाइफ इम्प्रिजनमेंट दिया था से जो दीटा मर्डर केस सिंगल मर्डर हां तेणु डेथ सेंटेंस हेई छी जे तो
because of
सब गुडा मिसई देले ना
one day occurrence, series of occurrence taken in one FIR.
You see, come to the section 218 of CRPC.
Separate charges for distinct offenses. For every distinct offense of which any person is accused, there shall be a separate charge, and every such charge
shall be tried separately, provided that where the accused person by an application in writing so desire, and the magistrate is of opinion that such person is not likely to be prejudiced thereby, the magistrate may try
Joinder of charge.
together all and any number of the charges.
Joinder of charges could be there, but you see what is there. Whether he has given it in writing that I will not be prejudiced. That has to be seen from the order sitting. Charge along with the order sitting.
And 220 is another section.
Well, for more than one of
them. That joinder of charges is there.
If in one series of acts so connected together, this is most important, as to form the same transaction. माने गोटे घटना हेची ता धेरे आकु बाडेची ताटू पैसा नहीं चली गला ताकू गाड़ी कला so एटा को same transaction so that's a different matter. More offenses than
there for connecting the all that.
It's my Goji in one series of acts so connected together as to form the same transaction. More offenses than one are committed by the same person. He may be charged with and tried at one trial for every such offense.
Charge order is just a simple one. Let's go to the He never raised this issue also. Accused has never raised this issue.
Order sheet charge the question.
नहीं lawyer
SDC appointment
SDC again.
And section 464 to come to that.
Effect of omission to frame or absence.
Please use the mic, Mr.
Effect of omission to frame or absence of or error in charge. No finding, sentence or order by a court of competent jurisdiction shall be deemed invalid merely on the ground that no charge was framed or on the ground of any error, omission, or irregularity in the charge, including any misjoinder of charges, unless, in the opinion of the Court of Appeal, confirmation or revision, a failure of justice has in fact been occasioned thereby. If the court, second, if the Court of Appeal, confirmation or revision is of opinion that a failure of justice has in fact been occasioned, it may, A, in the case of an omission to frame a charge, order that a charge be framed and that the trial be recommended from the point recommenced. That is
number B. Number B.
B. In the case of an error, omission, or irregularities in the charge, direct a new trial to be had upon a charge framed in whatever manner it thinks fit, provided that if the court is of opinion that the facts of the case are such that no valid charge could be preferred against the accused in respect of the facts proved itself was the conviction.
Here, the question of that, there is no prejudice that way. The charges are distinct and charges have been framed. There are such cases where the charge may not be there and court has proceeded. So unless a distinct charge is there, the accused may not get an opportunity to explain his case. So that is one aspect where this court can say charge be framed and matter be taken out. Additional evidence, if necessary, can be taken. Here, there is no aspect of charge having not framed. Charge has been
framed,
but it is in one charge. Now that charge
it may come within that irregularity.
220
So, ଏଇଟାକୁ ଯଦି ଏଇଠି ଫ୍ରେମ୍ କରିପାରିବନି error or irregularity କାରଣ ଦିଟା distinct offense ପାଇଁ ଯୋଉଟା ସାଙ୍ଗରେ ଆରଟା connected ନାହିଁ ତାକୁ ସେଇଟାର place of occurrence different.
well, kindly 220 sub section 4 my lord. If several acts of which one or more than one would by itself or themselves constitute an offense, constitute when combined a different offenses, the person accused of them may be charged with and tried at one trial.
Yes, that is what is joinder of one charge.
Yes,
that could possible.
ନାଇଁ ମନେକର ଜଣେ accused ଗୋଟେ ଜାବଡ଼ାଟା ମାରିଲା ତାପରେ ପୁଣି ଆଉ ଗୋଟେ ବାଡ଼ିରେ ମାରିଲା ତାପରେ ପୁଣି ଛୁରୀରେ ଷ୍ଟାବିଂ କଲା ହେଲା ତ ଆପଣ ଏଠି 323 କରିଦେଇପାରିବେ ଆପଣ ଇଏ ପାଇଁ କାରଣ ଚାପୁଡ଼ାଟା ମାରିଲେ 323 ହେଲା ତାପରେ ଇଏ ପାଇଁ ଆପଣ 325 କରିପାରିବେ ଏ ପାଇଁ 307 ମଧ୍ୟ ହେଇପାରିବ କିନ୍ତୁ ସେ କହୁଛି ଯେ ଯୋଉ several acts ଗୁଡାକ which one or more than one would by itself and themselves constitute an offense. 323 then constitute when combined with a different offense. That is, the person accused of them may be charged with or tried at one trial for the offense constituted by ତେଣୁ ଆପଣ ସେଇ ଯୋଉ ତିନିଟା ଆର୍ଟ କୁ ଆପଣ ଗୋଟେ ଇଏରେ ମଧ୍ୟ ହେଇପାରିବ କିମ୍ବା ଆପଣ ଯଦି ମେଜର ଅଫେନ୍ସ ମଧ୍ୟ ଆସିପାରିଲେ then there is no problem. ଯଦି କିଛି omission ବି ହେଇଯାଇଛି 323 ରେ ଆପଣ କରିନାହାନ୍ତି ଆପଣ that's a different matter totally.
307 ଅଛି 323 ନା actually.
ତେଣୁ ଏଇଗୁଟାକ ଟିକେ examine କରିବା 220 subsection 1 ଟା if in one series of acts so connected together so as to form the same transaction ଏଇଟା ଭିତରେ ସେଇଟା ଆସିବ କି ତାର କାରଣ ଆପଣ illustration 1 କୁ ଦେଖନ୍ତୁ illustration to subsection 1 A rescues B,
a person in lawful custody, and in so doing causes grievous hurt to C, a constable, in whose custody B was. A may be charged with and convicted of offences under section 225 and 333.
ordinarily criminal breach of trust first person order case गुड़ाक तीनटा डेट रे मन करो गोटे वर्ष रे चारटा मर्डर सेडा कोन गोटे ट्रायल नहीं होता that has to be taken because it is separate FIR एठी गोटे ये जी disadvantage is right from the beginning that FIR has been lost one FIR
ଆହୁରି ଅଛି ଆଦେରେ ଏଭିଡେନ୍ସ କୁ ଆମେ ଗଲେ unknown person identification tape has not been conducted again my lord one place somebody and that the combined ये ପାଇଁ କହୁଛି ତଙ୍କର जो ସେଇ ଲୋକ ସେଇ
the whole thing is that charge order is not clear. Charge order is as good as a simple one.
You see, even if on the basis of one FIR, which consists of different offenses committed at different place, that same FIR can be taken. It's all right, but you are to file charge sheet for each. That is the separate transaction. You should have filed the charge sheet, and the witnesses should have been different. The IO may be same, किंतु आपण एठी FIR टा रिलेट्स करछि पांचटा अकरेंस को चारटा अकरेंस को जोड़ा कि विभिन्न टाइम रे विभिन्न प्लेस रे किंतु FIR हे गला ठीक हो गला FIR आला law sets into motion but when during course of occurrence the IO found that it has taken place in different places and the deceased persons are different, witnesses to the occurrence are also different. And there is no link between one occurrence to the other. Only thing common is that accused has committed that those offenses are different places. So in that situation, the IO during course of investigation after finding it, he should have filed separate charge sheet against the same accused in which the witnesses might have been different.
And the
okay, matter is all right. That same FIR which has given rise to, like in this chit fund cases, you see, gote FIR hela, gote common FIR ହେଇଗଲା କିନ୍ତୁ ସେ ଯେତେବେଳେ ଇଏ କରୁଛନ୍ତି different ଇଏ କରିକି charge sheet separate file କରୁଛନ୍ତି ହେଲା ତେଣୁ ଆପଣଙ୍କର ଏଠି common FIR ହେଇପାରେ କିନ୍ତୁ ଯେତେବେଳେ transaction ଗୁଡାକ different ହେଇଯାଉଛି total ଆ ସାଙ୍ଗରେ ତାର କିଛି link ନାହିଁ then कारण आपण एटी गोटे चार्ज शीट ଦେଇଦେଲେ चार्ज शीट गोटे ହେଲା ବେଳକୁ କୋର୍ଟ କୁ ଚାଲି ଆସିଲା କୋର୍ଟ ତାକୁ ଜଏଣ୍ଟଲି ସବୁ ଦିଟା ଆପଣ ଫାଷ୍ଟ ଚାର୍ଜ ଟା ଦେଖନ୍ତୁ ଦିଟା डिसीज को ना मेंशन से दीटा डिसीज करो से कहार का संगे लिंक नाही अलग अलग जगह रे सेही दिन विभिन्न जगह रे हेछि ताकू whereas law says that for each distinct offense you should frame a separate charge
by trial by separate charge about it
each such charge
trial
tried separate
that has to
see
one matter series है ना गुट जा रहा है
for every distinct offense of which any person is accused there shall be a separate charge and each such charge shall be tried separately. So each question is whether common trial for these separate charges during course of same transaction if different offenses committed, it's all right, you can try him in one trial. But if the man is same, he has committed the offense for which you are to frame separate charges, that cannot be tried in one trial. There has to be a separate trial, tried separately. Language clear
184 section 184
184 charges to start supposed to
184 place of trial for offenses triable together where a offense is committed by any person or such that he may be charged with and tried at one trial for each of such offenses by virtue of the provision of section 219, 220 and 221 or the offense or offenses committed by several persons or it is several persons here. The offense may be inquired into or tried by any court competent to inquire into or try any of the offenses.
That deals with only three sections,
My lord,
219,
219,
220,
220,
221. We are in 218.
220.
218 is totally different from this
Right.
220, 220, 219, 220 and 221.
218, my lord.
ହଁ 218 ର
My lord.
ପ୍ରଥମଟା ଦେଖନ୍ତୁ ଏଇ ଲାଇଟ୍ ରେ ବହୁତ ଡିସିସନ ମଧ୍ୟ ଥିବ ହେଲା separate charges for distinct offenses committed by same person and that has to be tried separately देखिए এটা देख 218 है देखिए এটা देख You see what is the object of the section ଏଥିରେ କହୁଛନ୍ତି that the rule forbidding the joinder of charges have been framed for the benefit of the accused. The underlying idea is that if too many charges are grouped together against an accused, he might be handicapped or embarrassed in conducting his defense. Moreover, there is likelihood of the judge being unconsciously prejudiced against the accused when a large number of accusations are brought against him.
Illustration भी 218 illustration भी ଦେଇছে same. A is accused of theft on one occasion and of causing grievous hurt on another occasion. A must be separately charged and separately tried
That is
Yes,
what exactly.
that is it.
The object of section 218 is twofold. In the first place, to give an accused notice of the charges which he has to meet. In the second, to see that he is not embarrassed by having to meet charges in no way connected with one another.
That is how it must be one time.
Question is that ଏଇ ଯୋଉ situation ଆମେ ତ ଯାଇନୁ evidence କୁ ଆପଣ ଯାହା ମୁଁ କହିଲେ ଦି ଜଣ ଯାକ before the bench the submission was made that though the accused is same but the occurrence has taken place at different places at different point of time and there is no connection with one case to the other. It's a totally separate transaction.
And also the witnesses
are also different. Here the witness is different
What
totally.
is 300 meters, 200 meters
That's different.
away from that place. So,
And it is in the night hour, mid of the night.
unless a
Connection.
there is an order in that to that effect that this transaction is one, either they were involved in one, that is how he went to different places
Different
and
place, yes.
took step. That is not there. The order is very silent. Order is silent. Order is as if it is one transaction.
But again, you examine that case of that Bombay blast case, that
Yes,
Taj. It was distinct. One first in that railway station, the other is that another places. So bomb. Then they went to that Taj hotel, committed one. So all these things that was tried together.
Yes.
Why it was tried together? Because it has got some kind of link.
Link and intention.
Conspiracy was there.
Conspiracy there.
ଏବଂ ସେମାନେ ଏଇଥିର ତାଙ୍କ ଭିତରେ ସେଗ୍ରିଗେଟ୍ ହେଇଯାଇଥିଲେ ତୁ ଆକ୍ୟୁଜ ଯା ସେଠିକି ସିଏ ଯା ସେଠିକି ଆମର ଏଇ ପର୍ଟିକୁଲାର ଟାଇମ ରେ ସବୁଠି ଇଏ ହବ ସେଇ କନସ୍ପିରେସି କୁ ଏକ୍ସିକ୍ୟୁଟ କରିବାକୁ ଆଗେ ତାକୁ ସେଟା ପ୍ଲାନିଂ ହେଇକିନି ଏମିତି ହେଇଥିଲା ତେଣୁ ସେଥିପାଇଁ ଗୋଟେ ଟ୍ରାଏଲରେ ଗୋଟେ ଇନଷ୍ଟାନ୍ସ ସେଠି ଆମେ ଦବାକୁ ଚାହୁଁ ଯେ ଏଠି ତ ବିଭିନ୍ନ ଜାଗାରେ ହେଲା ଏବଂ ଏ ଆକ୍ୟୁଜ ତ ସେ ଜାଗାରେ ଇନଭଲ୍ଭ ନଥିଲା ସେଠି ବି ନ ତାହେଲେ ସେମାନେ ଏକାଠି କେମିତି ଟ୍ରାଏଲ ହେଲା. Maybe the reason is that the conspiracy was hashed out and they are acting.
One accused, no conspiracy. One accused here. One accused, so there is no conspiracy. And
oh, say Bombay case. Seta the other accused persons were killed. Only one left out. He faced trial and ultimately sentenced to death. ତା ଦେହରେ ମଧ୍ୟ ଏଇ ଟାଇପ ରହିଥିଲା ତା ଦେହରେ ମଧ୍ୟ ଆସିଛି ଗୋଟେ ତ ଏଠି ହେଲା ଗୋଟେ ସେଠି ହେଲା ଆଉ जो प्रथम इंसिडेंट रे ए अक्यूज अलगा से सेकंड इंसिडेंट रे अक्यूज्ड अलगा थर्ड इंसिडेंट रे अक्यूज तापर से माने कंबाइंडली गले से जो ताज होटल को गले सेटा होची अलगा तेनु बट it has got link with
that is one transaction
one transaction
is different
they met one place and again went to the hotel
but here transaction seems to be different transactions are different that we have to see on this aspect.
You have to examine it.
Why it has been taken together? Both have just taken it without one charge.
One charge sheet was filed on.
Because now, since you see, we are thinking of it. Suppose once it is found that it goes to the root of the matter, there is likelihood that the accused has been prejudiced, and particularly the sentence part.
Yes, that is
their sentence is imposed because of that tried together. if it would have been tried separately, maybe that for
Maybe
each
different-
offense, each
each offense
302
life
case, life ହେଇଥାନ୍ତା ତ ଡେଥ୍ ହେଇଛି ଏଇଥିପାଇଁ ହଁ ତେଣୁ ଆପଣଙ୍କର you see ଯୋଉ
rare to rare case under
multiple murders committed in one transaction, it's all right. See death sentence ମଧ୍ୟ ଇଏ କିନ୍ତୁ ଏଇଟା ଗୋଟେ different ଇଏରେ ହଉଛି ତେଣୁ ସେଠି how far it is justified. Then again the question would arise, FIR 1, charge sheet 1, then how these things, how the justice can be done. Now you are to, on the basis of that same FIR, same charge sheet, now if the opportunity is given to segregate the charges and the accused is to ask to face different trials, then he may be asked to face 3 trials for 3 distinct offenses because of the fact
4 trials
କୌଣସି କାହା ତାର କାହାର link ନାହିଁ. So in that case one may be tried in the court of magistrate also.
Yes, sir.
That
Two cases will go to
ନାଇଁ
magistrate.
ସେଇଟା ତ ହବ ନାଇଁ କାହିଁକି ନା the higher offense, the court who will be hearing the higher offense has to take up all the matter irrespective of
ନାଇଁ ସେ
different
ସେ ଯୋଉ ଦିଟା ମଧ୍ୟ ଆଉ ଗୋଟେ ଜାଗା
different place
ସେଠି 307
ସେଠି 307 ଖାଲି ଅଛି
ସେସନ୍ସ ଅଛି
sessions ଅଛି
session trial ଆସିଯିବ
ହଁ sessions
but
ସେସନ୍ସ
it may go to the, or because of the that he has got power, he may try that session judge ର power ଇଏ ନାହିଁ, but it is to be registered as a separate ST case. separate ST case ହବ ଏବଂ trial is separate ହୁଏତ 4ଟା judgment ହେଇପାରେ
ଆଜ୍ଞା
କାରଣ ୱିଟନେସ୍ ବି ଆପଣ ଯାହା ଆମେ ଯାହା ଆପଣ ଯାହା କହିଲେ ଯେ ପ୍ରତ୍ୟେକ ଇନସିଡେଣ୍ଟ ପାଇଁ ୱିଟନେସ୍ ମଧ୍ୟ ଅଲଗା ହଁ ଏ ମର୍ଡର ପାଇଁ ୱିଟନେସ୍ ଅଲଗା ଯାହାର ଲିଙ୍କ ନାହିଁ ସେ ପାଇଁ ଆସଲ୍ଟ ପାଇଁ ଅଲଗା ତେଣୁ ହେଇଥାଇପାରେ ଯେ କେବଳ କନଫାଇନ୍ ହବ ସେଇ ଲିମିଟେଡ୍ ୱିଟନେସ୍ ପ୍ଲସ୍ ଆୟୁ ହୁଏତ କମନ ରହିପାରେ ସେଇ କେସ୍ ର ସିଜର ହୁଏତ ସେ ହଁ. So that is to be segregated in that way, and he may be asked to face number of trials. We are just opening up so to examine.
Seizure को असले प्रयास है seizure ଭିତରେ ଆଉ ଟିକେ exhibit ଦେଖିନି seizure ରେ seizure list ବି जो occurrence ଜାଗାରୁ ଉଠେଇଛନ୍ତି different ଇଏରୁ ସେ ଗୋଟେ ଜାଗାରେ ଗୋଟେ seizure କରୁଛି ମୁଁ ଟିକେ verify କରିଦେ ମାନେ different place
of seizure is different.
ନାଇଁ
ଗୋଟେ
seizure list
common seizure list
ଗୋଟେ seizure ଗୋଟେ ହେଇଛି just verify
doesn't matter what those aspects are
main thing is that এই जो provision টা রহুଛି
218
218 no, for each every distinct offense of which any person is accused, there shall be separate charge and every such charge shall be tried separately. ତାକୁ analysis କଣ ପାଇଁ tried separately କଣ ପାଇଁ ଉଦ୍ଦେଶ୍ୟ ତାର କଣ ସେଟା କୁହାଯାଇଛି ଏବଂ ତା ଦ୍ୱାରା କେମିତି ପ୍ରିଜୁଡିସ୍ ହବ ନାହିଁ accused ଆଉ ଏମିତି ଜଏଣ୍ଟ ହେଇଗଲେ କଣ କୋର୍ଟ ର ବାୟାସ କେମିତି ଆସିବ ଏଠି ଯେମିତି ମାଇଣ୍ଡ ଆସିଯିବ ନା ତାହେଲେ 3ଟା ମର୍ଡର କରିଥିଲା ସେଠି ଯଦି ହେଇଥାନ୍ତା
different
ହଁ ଏଇ ମର୍ଡର କଲା ଏଠି ସେ କିଏ କଲା ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍ କାରଣ ଗୋଟେ accused କୁ ଆପଣ ଜଷ୍ଟ ଦେଖନ୍ତୁ suppose one accused is found guilty under 302 case under section 302 and sentenced to life imprisonment. So what would be the procedure would be adopted in case in the 4th trial, okay, this 3 conviction is brought to the notice of the trial court, then what will happen? That is another thing. ଯେ ୟା ନାଁରେ ଏଇ ଟାଇପ ର ପ୍ରିଭିୟସ କନଭିକ୍ସନ ରହୁଛି ଯୋଉଡାକର ମଧ୍ୟ ଇଏ ତାହାର ମଧ୍ୟ ଇମ୍ପୋର୍ଟାନ୍ସ କଣ ଅଛି କି ହେଲା ତେଣୁ ବଟ୍ ଅର୍ଡିନାରିଲି 302 ରେ ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ ଏଇ ଟାଇପ ର ସିଙ୍ଗଲ ମର୍ଡର ଏକ୍ସେପସନ କାହିଁକି ହେଇଯାଉଛି ଏଇ କେସରେ ବିକଜ ଇଟ୍ ଟ୍ରାଏ ଟୁଗେଦର ଗୋଟେ କମନ ଚାର୍ଜ ହେଲା ଦ୍ୟାଟ ଇଜ ଦି ରିଜନ there is no doubt that the object of section 218 is to save the accused from being embarrassed in his defense if different offenses are lumped together in one charge or in separate charges and tried together. Legislature has engrafted certain joinder of charges, certain exceptions upon this rule contained in 219, 220, 221 and 223. ସେଇଗୁଡାକରେ ଯୋଉ exception ଆସିବ so that is separate charges ମଧ୍ୟ ହେଇପାରିବ tried together ହେଇପାରିବ ଗୋଟେ trial ରେ. Mr. Panda, you have been engaged as amicus curiae, I think. So have you examined this point?
No.
You are to assist this court. This is the main point on the threshold it struck to our mind. And that is how we put the pertinent question to you.
Mr. Panda, your responsibility towards the court is not to defend the accused. Your responsibility is to assist the court as amicus.
We seek your assistance because the amicus curiae's role is that.
You have not been engaged to defend the accused.
Right.
You have been engaged at amicus curiae to assist the court. So kindly examine this aspect by both of you.
ଗୋଟେ ପଏଣ୍ଟରେ ବି ଅଛି ରେ to proceed.
Mentally unsound also. The order sheet shows the district
464 को ଏବେ ଯାଆନ୍ତୁନି.
ଆମେ ସେଗୁଡାକ ସେ ଅଲଗା ଜିନିଷ ଆମେ ଯୋଉ threshold ରେ ଅଛୁ ସେଇଟାକୁ ମିଟ୍ କରିବାକୁ ଚେଷ୍ଟା କରନ୍ତୁ କାରଣ its consequence may be different ହେଲା. ମୁଁ ସେଇଥିପାଇଁ ପଚାରିଲି ମୁଁ କହିଲି ହୁଏତ ତାର ଲିଙ୍କ କିଛି ଥିବ ଇଏ ଥିବ କଣ କିଛି ନାହିଁ.
Anyway, but on this aspect, the law is also very clear on several aspects. You can the question of examination only there. It should not happen that because of this the accused would be prejudiced, or the likelihood of a court getting biased going to a severe punishment, capital punishment.
So you go, both of you go through these books and also the law laid down and examine all these provisions which are there under the heading of so and so. And we can take up this matter when you want it. Is it 2 to 3 days time we can give you? So but tell Mr. Panda then to start his matter tomorrow because this case we are adjourning. Panda's matter.
I have to take some time. That's why I ask him. We'll take the
Then you have to make this jail criminal
Jail
appeals
criminal.
also. At least one
Yes,
or two you can
we'll go on that.
that will
Yes.
do. There is no problem there. So then we are keeping it to the next week. There is no problem. We are keeping it to 8th. Left one. Heard the learned counsel for the learned amicus curiae, Mr. Jugal Kishore Panda and Mr. Orupananda Das, learned additional government advocate. The hearing commenced and the appellant appeared to virtual mode from such and such jail. After placing the past information report and charge framed against the appellant by the Lennon trial court on 4/3/2021, we found that for commission of murder of two different persons at two different places at two different times, the appellant has been charged under one heading. And similarly, under what heading? Under section 302 IPC. Similarly, for the assault on two persons, namely Sulochana Pradhan, bracketed PW13, and Amuli Barik, bracketed PW5, at different time and different places, the London Trial Court has framed charge under section 307 of IPC under one heading. The London Council for the state, so also the London amicus curiae, submitted that in this case, apart from the two deceased, Vadani Pradhan and Lochan Sethi, there are three injured persons, namely Sulochana Pradhan, PW13, Amuli Barik, PW5, and Damodar Sahu, PW15. And since the one common FIR was given relating to all transactions by the informant Manoj Sethi, bracketed PW2, the investigating officer, on completion of investigation, submitted charge sheet on 9/7/2019 relating to all those offenses which took place at different time at different places with different persons. And the London Council also submitted that the evidence on record indicates that there is no link between one occurrence with the other, and it cannot be said to have committed in one transaction. Section 218 of CRPC states that for every distinct offense of which any person is accused, there shall be a separate charge, and every such charge shall be tried separately, provided that where the accused by an application in writing so desires, and the magistrate is of the opinion that such person is not likely to be prejudiced thereby, the magistrate may try together all or any number of charges framed against such person. Stop. After verifying the order sheet of the London Trial Court, we did not find any such application has been filed by the appellant, uh, and and no order has also been passed by the London Trial Court uh, that the appellant will not be prejudiced if he is tried together for all these charges. This section seems to be mandatory, and for every distinct offense, there should be a separate charge which should, except in certain cases specified in section 219, 220, 221, and 223 of CRPC, be tried separately. Each offense should form a separate head of charge with reference to which there should be a distinct finding and a distinct sentence. The trial of each of the charges should be separate. Separate offenses should not be lumped together in one single charge. Rules forbidding the joinder of charges have been framed for the benefit of the accused. The underlying idea is that if too many charges are grouped together against an accused, he might be handicapped or embarrassed in conducting his defense. Stop. Moreover, there is likelihood of the judge being unconsciously prejudiced against the accused when a number of accusations are brought against him. The The London Council for the states, also the London Council, amicus curiae, seeks time to examine this issue and address this court on the next date, uh, and accordingly, this matter on 8th of July 2024. Free copy of the order be handed over to the learned counsel for both the parties.
My lord, tomorrow, my lord, the for admission matters there from 38. 4 matters are there. Can it be taken up tomorrow first?
No, this
Only hearing matter.
Only hearings will take up this matter. There is. So who are these admission matters means? Yeah, consider.
Because there is an admission matter. WPC is there. And another WPC that is Jagar Singh, that is.
Wait, let us see the list. At 8 learned counsel learned counsel for the learned amicus curiae filed the written note of submission which is taken on record. ଏଗୁଡାକ ଇଏ କରି seal ମାରିକି ରଖ ସେମିତି ରଖନି. Yes, Mr. Das କଣ କହୁଥିଲେ item number
item 38 ଆଉ 40 ଦିଟା WPC ଦିଟା ଅଛି for admission ରେ. The 40 ଟାରେ my lord recall my lord that records are called for
the land council.
The pen drive.
You have taken it.
And 39.
What is this?
And for 38 also today they are present.
39 is it comes under in the head of the orders, your lordship, but wrongly it was listed in admission. Because your lordship, my lord is to decide the bail application and to have relation fine. Stay relation.
Okay, then we can take up this matter. There is no problem. So we can take up tomorrow. This item number, let us say item number 42, it is placed for admission, prisoner's petition at flag A. कौन एटा देखी एटा हम ए जो एनगेज कराई छी तांको अभिषेक महांती हम एनगेज करिछु so prisoner's petition at flag A regarding condonation of delay as this case was received in this so this case we can condone the delay. It's I think it's a life imprisonment. 302 life imprisonment is there. Of course, another offense is there also 458. And where is Mr. Abhishek Mahanti?
They are in the first term.
Then you ask him to remain present tomorrow in the first term. We can.
So that I can, that's why I asked my lord, so that I can intimate the bar that this matter will be taken up, so that.
Then we'll go to the hearing. Yes, 5 matters are there. So.
And one thing, my lord, that is item 46, my lord. Prem Kumar Patnaik. He already died, my lord. So in that case, somebody else may be engaged, so that.
46 ର file ଟା sample ପଠେଇ लिखी दे Mr. Prem Kumar.
If here
it is stated at the bar that the Mr. Prem Kumar Patnaik is dead and so on so sir जाके engage करिए don't forget.
If my lord here Mr. Soman is there, if he is maybe engaged, he can take up the matter day after tomorrow. So
who?
Mr. Pani there. If my lord will engage him,
name appears in the
No,
list.
no, I am not.
Name doesn't appear.
Legal investigation.
There is no point.
Kindly take his book. Bar enrollment number.
थोड़ा सा वो दरकार 10 years practice.
Yes, madam. He has already more than 20.
So cancel paper book का भी दो. Paper book hand over कर दियो तो नाम नहीं जान तो noting टा. Anything else, Mr. Das?
No, madam.
So you just tell the learning council to.
Yes, I will intimate
from 38 and some of the bail applications also in absence of the counsel, we have just not passed any order. We'll again call this matter tomorrow because it is for the entire week. So wherever the counsels are absent, if
I'll give a notice to
phone
the-
numbers are available, just intimate.